morning, everybody, and welcome to the City Planning Commission public meeting. And I think on behalf of all of my fellow commissioners, I want to welcome back our dear colleague, Michelle Delahousse, and just say our hearts are with you. And Madam Secretary, please begin.
Good morning. This is the City Planning Commission public meeting held in Spector Hall, 22 Reade Street. Today is August 24th, 2016. As a courtesy during the proceedings, we ask that you please turn off all cell phones and beepers. All speakers should fill out a speaker's card at the desk outside of Spector Hall. In addition, we ask that those providing testimony please identify yourself, limit your remarks to 3 minutes, and speak clearly into the microphone. I will now call the roll. Chairman Weisbrod.
Here.
Vice Chairman Knuckles. Commissioner Besser. Commissioner Cantor. Commissioner Cerullo. Commissioner Delahousse. Commissioner Dweck.
Here.
Commissioner Eady.
Here.
Commissioner Efron.
Here.
Commissioner Knight.
Here.
Commissioner Levin. Commissioner Marin.
Here.
Commissioner Ortiz.
Here.
A quorum is present. The first item is the approval of the minutes of the special meeting of Monday, August 15, 2016.
On the minutes, may I have a motion to approve?
Second.
All in favor?
Aye.
Any opposed? Any abstentions? Madam Secretary, the minutes are approved.
Scheduling. On calendar numbers 1 through 10, we have resolutions for adoption. Scheduling Wednesday, September 7th, 2016 for a public hearing to be held in Spector Hall, 22 Reade Street.
On the resolutions, may I have a motion to approve?
So moved. Second.
Any discussion? All those in favor?
Aye.
Any opposed? Any abstentions? Madam Secretary, the resolutions are approved.
The next part of the calendar is the report section on page 22.
And Madam Secretary, I do note that Commissioner Cantor is here as well.
Oh, he is? Okay. Oh, okay. Okay, thank you. Okay. Borough of Queens, calendar numbers 11 and 12. Calendar number 11, CD 14, C160219, ZMQ. Calendar number 12, N160220ZRQ. In the matter of applications for zoning map and zoning text amendments concerning Rockaway Beach Boulevard rezoning. For favorable reports on calendar numbers 11 and 12, Chairman Weisbrod.
Yes.
Commissioner Besser.
Yes.
Commissioner Cantor. Yes. Commissioner Delahousse. Yes. Commissioner Dweck. Yes. Commissioner Eady.
Yes.
Commissioner Efron.
Yes.
Commissioner Knight.
Yes.
Commissioner Marin.
Yes.
Commissioner Ortiz.
Yes.
Favorable reports have been adopted on calendar numbers 11 and 12. Borough of Queens, calendar number 13, CD9, N170019, PXQ. In the matter of a notice of intent to acquire office space for use of property located at 126-06 Queens Boulevard for Queens District Attorney. For a favorable report on calendar number 13, Chairman Weisbrod.
Yes.
Commissioner Besser.
Yes.
Commissioner Cantor. Yes. Commissioner Delahousse. Yes. Commissioner Dweck. Yes. Commissioner Eady.
Yes.
Commissioner Efron.
Yes.
Commissioner Knight.
Yes.
Commissioner Marin.
Yes.
Commissioner Ortiz.
Yes.
A favorable report has been adopted on calendar number 13. Borough of Staten Island, calendar number 14, CD1, N16004ZAR, in the matter of an application for the grant of an authorization concerning the Pavilion Hill Terrace for adoption on calendar number 14. Chairman Weisbrod.
Yes.
Commissioner Besser.
Yes.
Commissioner Cantor.
Yes.
Commissioner Delahousse. Commissioner Dweck.
Yes.
Commissioner Eady.
Yes.
Commissioner Efron.
Yes.
Commissioner Knight.
Yes.
Commissioner Levin. Sorry. Commissioner Marin.
Yes.
Commissioner Ortiz.
Yes.
Calendar number 14 has been adopted. Borough of Staten Island, calendar number 15, CD3, N160370RCR, in the matter of an application for the grant of a certification concerning Downs Avenue. For adoption on calendar number 15, Chairman Weisbrod.
Yes.
Commissioner Besser.
Yes.
Commissioner Cantor.
Yes.
Commissioner Delahousse. Commissioner Dweck.
Yes.
Commissioner Eady.
Yes.
Commissioner Efron.
Yes.
Commissioner Knight.
Yes.
Commissioner Marin.
Yes.
Commissioner Ortiz.
Yes.
Calendar number 15 has been adopted. And the supplemental calendar, number 1, citywide, calendar number 1, in the matter of a CAPA rule change for Coastal Commission for adoption on calendar number 1. Chairman Weisbrod,
Yes.
Commissioner Besser,
Yes.
Commissioner Cantor, Commissioner Delauss, Commissioner Dweck, Commissioner Edie,
Yes.
Commissioner Efron,
Yes.
Commissioner Knight,
Yes.
Commissioner Marin,
Yes.
Commissioner Ortiz. Calendar number 1 has been adopted. The next part of the calendar is the public hearing section on page 27. Borough of Brooklyn, calendar number 16, CD 10-160377 ZRK. A public hearing in the matter of an application for an amendment of the zoning resolution concerning the Brooklyn Community Board 10 text amendment.
First speaker is Josephine Beckman from Community Board Number 10 in Brooklyn.
Good morning, Commissioners and Chairman Weisbrod. My name is Josephine Beckman, and I am the District Manager of Community Board 10 and the applicant in today's submission to the New York City Department of City Planning for a zoning text amendment to a Board of Standards and Appeals special permit, ZR 73622, enlargements of single and two-family detached and semi-detached residences. We are seeking the removal of CD10 from its current applicability under existing regulations. Community Board 10's decision to submit this application to eliminate the special permit is based on 13 years of study and experience with the special permit and how it has been handled by the Board of Standards and Appeals. CB10 believes that the original intent of ZR 73622 was to allow existing residents a mechanism for relief from noncompliances, allowing modest expansions and an ability in the zoning text to enable growing families to remain in their homes by enlarging kitchens or building additional bedrooms. Board members at the time supported a provision in this section that included community character to be considered regarding whether an application should be granted. Notably, since its adoption by City Planning in February of '98, only 21 special permit applications have been applied, and of these applications, half were disapproved by CB10. Of those that were disapproved, all were approved by the Board of Standards and Appeals. CB10 members have been on record 4 times in the last 13 years to remove CD10 from ZR 73-622. CB10 supported inclusion, although at the time there was great citywide opposition, and only 5 community boards opted in citywide. The original land use justification for the applicability of the special permit has in practice been predominantly used to legalize existing illegal conditions or to produce luxury housing for speculative sale or purchase BSA BSA approved all applications regardless of community opposition. BSA never prescribed conditions or safeguards suggested in our recommendations to the BSA to minimize adverse effects on character of the surrounding area. The 3 recurring ZR 73-622 objections impacting community character include no limits on the amount of floor area ratio expansions, horizontal and vertical enlargements of non-compliant side yards, and rear yard encroachments to 20 feet. CB10 believes that future enlargements should adhere to the as-of-right residential regulations, proceed within the established relief offered by way of BSA variance, or provided under an alternative existing special permit, ZR 73-621, enlargement, extension, or conversion of buildings containing residential uses that limits enlargements to 10%. Following certification of its application, Community Board 10 held a public hearing on June 15, 2016, with broad public outreach and notification. The public notification included a 6,000-piece residential district mailing to those areas in which this section of the special permit has been granted in the past. Notices were also sent to the local press, community groups, civic organizations, houses of worship, elected officials, prior applicants, as well as local real estate brokers, architects, and land use attorneys. Okay. Just to sum up, we had a very large public hearing. Majority of speakers spoke in favor, and we're here today to just demonstrate to you that we have widespread support for this text amendment within Community Board 10. Thank you.
Thank you, Ms. Beckman. Questions for Ms. Beckman? Ms. Ortiz?
Hi,
Hi,
thank
good
you for
morning.
your testimony. You mentioned, originally there was support for the provision to allow for enlargements that were reasonable. Without this provision, what do you see, being the solution for individuals who would like to, enlarge for the original reasons.
Yeah, I think that what I cited in my testimony was there's an alternate special permit provision in the text 621, 73-621, and also the variance.
Thank you.
Any other questions for Ms. Beckman? Hearing none, thank you very much, Ms.
Thank you.
Beckman. The next speaker is Councilmember Vincent Gentili. Good morning, Councilmember.
Good morning. Good morning, Chair Weisbrod and the members of the commission. Thank you for your continuing good work. There we go. As the city councilman representing the area covered by Brooklyn's Community Board 10, I come today to speak in support of the Community Board 10's application before this body to repeal their participation in ZR 73-622 of the zoning regulations by repealing this section in regard to Community Board 10. It is my understanding that when passed in 1997, CB 10 was one of 5 community districts in Brooklyn included in this provision. The Community Board felt that such a provision to offer a special permit process would allow current residents to, in effect, grow in place. That is, give owners of detached and semi-detached 1- and 2-family homes the option to easily add a needed bathroom, den, bedroom, or other reasonable living space without having to move to new premises or to leave the neighborhood. Even at the time of the community's historic downzoning in Bay Ridge in 2005 and in Dyker Heights in 2007, the need to grow in place was still an ongoing concern, and the special permit remained in place. Yet, over the years, it has become clear to me and to the members of the board that this provision, in reality, has more often been used by speculators and investors and new buyers of property within CB10 to add bulk immediately upon the purchase of the property or to make legal an illegally converted space. And with few limits placed in the authorization language of ZR 73622, it has become evident that the misuse of the special permit has been intentional and repeated. And so the Community Board has voted in 10 of the 21 applications over this period against the granting of the special permit to property owners. Each time the board voted to deny, they argued that the change in the essential character of the neighborhood would occur if the permit were granted. This argument is one analysis that the law requires BSA to make in evaluating these special permit applications. Yet, despite the negative vote from the community, and in large part because the term, the change or effect in the essential character of the community is not defined in the regulation, the BSA board has approved every special permit to come before it from Community Board 10, every permit application granted since 1997. Indeed, former BSA Chair Seversian commented at one such vote in 2013 that maybe the Community Board should move to revoke the special permit since she saw CB10 appear so many times at BSA in opposition. And so that brings us to this application pursuant to the vote of the CB10 Board in December last year to call for the removal of the CB10 from the special permit provisions. As you know, and as was said just a few minutes ago, such removal of CB10 does not preclude or cut off requests or plans for future enlargements of property. We still want families to grow in place, and there are still several ways to seek relief for residents, including ZR 773-621 special permit and through the use of a zoning variance. Now, if I may.
Keep going. Yes.
Now.
You have the special privilege of elected officials of not being bound by the clock. So.
Thank you. Wrapping up. Now, it is my understanding that currently there are 4 applications under this permit for properties within CB10 that are either pending before or have been approved by the Board of Standards and Appeals. In consideration of these applications, I am preparing, in conjunction with the City Council Land Use Division, a text amendment that would vest these applications and grandfather them within the current provisions of the special permit. We are currently working on a date by which an application would come within this vesting amendment, and a date by which construction on the premises would need to commence once the permit is granted by the BSA. Presuming that this vesting provision would be used as intended, that is, to allow current applications to rely on the current permit and not be abused with a flurry of new applications before the rescinding of the permit with respect to CB10, I anticipate having language and text prepared at the City Council stage of this process. So what we are asking the Commission to do today in voting affirmatively on this application and sending it to the City Council for a vote, we think is the prudent and necessary step to take to preserve the downzoning of 2005 and 2007 and prevent the willful erosion of the contextual character of the neighborhood by an end run around the contextual zoning. And we believe this repeal will stop the abuse of what really started out as a well-intentioned benefit of the zoning law. Therefore, I fully support this effort and appeal to this body for an affirmative vote on this application. I thank you for your time.
Thank you, Council Member. Questions for Council Member Gentili? Commissioner Delausse.
Councilmember Gentili,
Yes.
thank you for being here, and honestly, you anticipated my question, which was about pending applications, so I appreciate you thinking ahead on that. I was in the neighborhood recently and noted some of the construction and speculation that you're referencing, so I appreciate your being here.
Great, thank you.
Any other questions for the Council Member? Commissioner Efron.
Thank you, Councilmember.
Yes.
You are confident that you could draft the text so that there wouldn't be the unintended consequence of a flurry of applications coming?
Yes, that's what we're working on that now. Our land use division is working on that language right now.
Okay. Are you aware of others that are ready? Has the community
No,
board?
I'm not aware of anything at the
Terrific.
moment.
That's very helpful. Thanks.
Thank you, Commissioner.
Any other questions for the Council Member? Thank you.
Great, thank you. Thank you all.
The next speaker is Robert Casara from Brooklyn Housing Preservation Alliance. Mr. Casara.
Good morning, Commissioners and Chairman Weisbrod. I'm Bob Casara, a lifelong resident of Bay Ridge and Dyker Heights, and I am opposed to the special permit ZR Section 73622. Bay Ridge and Dyker Heights is set up and designed to protect, zoning is set up to, and designed to protect the character and charm of our community. In the mid-2000s, the Community Board 10, along with the elected officials, lobbied the city to downzone Community Board 10 because of the as-of-right abuses that we saw happening in our community. Single-family homes were being torn down and replaced with much larger, out-of-scale, and out-of-character multifamily buildings. We were successful, and an agreement was reached with the city, and most of our community was downzoned. Based on what I have learned, there have not been many requests, approximately 20 for home enlargements in Community Board 10, and just a few have been given permission to increase the size of buildings in our community by the Community Board. However, in spite of our Community Board's diligence in safeguarding the community, the Board of Standard and Appeals approved all applications despite instances where the Community Board 10 members raised objections that the expansion projects did not conform to the intentions of the statute and adversely affected community character. In many of the cases where ZR 73622 permit applications were approved, the result is that it doesn't reflect the initial intent of the special permit, but resulted in many enlargement applications for luxury expansions, speculative purchases, or legalizations. Now we are faced with still another and even greater challenge. Our community is under siege by unscrupulous developers and investors who are illegally converting our predominantly one- and two-family homes into SROs. This, in turn, is causing overcrowding of our schools, 170% health hazards, strains on our sanitation services, and risk to our first responders. These developers are illegally converting them under our very noses and those of the Department of Buildings. The DOB should be preventing this illegal behavior, but they and other city agencies have been unable to stop it. If left unchecked, in time, it will break our zoning. The developers, investors, and investors will seek to enlarge their property in order to make SROs that contain even more units. I fear that the special permit ZR Section 73-622 will only give these opportunists the as-of-right ability to cause even more destruction to our community, thus changing its very character for good and eliminate the reasons why so many of us for so long have called this place home. Once the tipping point is reached, our community will be changed forever and will not be a place that any of us recognize or wish to continue to live. Accordingly, I support Councilman Vincent Chantilly and our community board's request for special permit 73-622 to be rescinded. Thank you very much.
Well timed. Thank you very much, Mr. Casara.
Thank you.
Before you leave, questions to Mr. Casara? Now you can leave. Thank you. Thank you.
Thank you.
The next speaker is Steve Harrison from Community Board 10.
Good morning, Mr. Chairman and Commissioners. My name is Stephen Harrison, and I'm a lifelong citizen of Brooklyn and a resident of Bay Ridge. I speak in support of the application. I'm a past chair of Community Board 10, and I have been the chair of our Zoning and Land Use Committee at least twice and for a total of 10 years. I was a leading proponent during our long, successful fight for rezoning in the early 2000s. I have long advocated for the elimination of the special permit now before you. I believe it is the antithesis of good zoning. The original driving concept behind this special permit never made much sense if you really think about it. The purpose was to allow young homeowners who are already entrenched in their homes and communities to make modest, non-conforming enlargements to accommodate growing families. But the only real restriction on the enlargement is that it conform to community character. The problem is that community character is an amorphous and subjective term undefined in the zoning resolution. It's the functional equivalent of saying that we think these should be gorgeous or beautiful or really neat looking. In short, they really mean nothing. And because it means nothing, the Board of Standards and Appeals has never once applied that standard, probably because they can't agree on what community character is either. The effect has not been to give a helping hand to growing young families, to allow them to stay in their homes through minimal zoning relief, as was intended. Instead, the effect has really been to nullify our board's rezoning in the applicable zoning districts. What's the point of requiring 30-foot rear yards in the main zoning if you can reduce that to 20 feet just simply for the asking? And the same thing is true with floor area ratio. And generally speaking, what's the point of any absolute limit in the principal zoning if you can bypass that just for the asking? Remember, the Board of Standards and Appeals has never said no to one of these special permits. Ironically, the people who have benefited are not the young people with the growing families as intended. It's been people with ample means who simply want more luxurious accommodations. And that's not wrong. The applicants are generally welcome and productive members of our community. And I don't mean to disparage them. But they are well within their rights under this special permit. But it's not what was intended when we added this to our zoning. And despite the hoots and hollers from the neighbors who unfairly have their light and air cut off because of this, we at Community Board 10 are powerless to stop it in the face of a non-adoptable BSA. There are other ways to apply for enlargements, but these other devices, as of right enlargements, variances, and a potpourri of other special permits, all come with tighter controls and restrictions. We will not miss this one out-of-control special permit. Thank you very much.
Thank you very much, Mr. Harrison. Questions?
Yep. Thank you.
Thank you. The next speaker in opposition, Richard Lobel.
Chair, Commissioners, good morning. To the extent one can feel affection for a regulation in the zoning resolution, I feel affection for Section 73-622. For who would not love a provision which at its core was created to allow growing families to stay in Brooklyn? And so since its inception, our office and other offices have made application to BSA, which has allowed growing families numbering in the hundreds and even thousands of Brooklyn residents to remain in Brooklyn despite rising costs and also has allowed people to remain in their communities, which is perhaps the most important. And so we've argued this before BSA, we've argued this before the courts, and indeed the appellate division, which has upheld the broad applicability by BSA of the provisions of 73622. Indeed, the reason for the designation of 73622 was because of the difficulty posed by applying for and receiving variances for single-family homes. Because due to the technical findings of 7221 and the variance provisions, it is a hard road to take to enable a family to enlarge their home in the face of uniqueness and similar findings. And so to hear that 73621, the other provision, can be used to substitute for 73622, we don't really understand or find that to be comparable, because those enlargements, according to the rule, are only for 10% greater than the allotted floor area in the zoning district, and so many non-complying homes would be unable to use this from its inception. However, we understand that the special permit was originally approved pursuant to a process, and we understand now that it's that there is a proposal to amend it by a process, and so we respect that process. And while we again have love for this special permit, we understand that there are those who would choose not to have it in their community. So while we are on record as saying that we support 73622 in its current iteration, we would ask that the proposed text amendment, as has been suggested by the council member, be adopted by the commission. Indeed, we have forwarded a provision, a sample provision, 11340, to the commission, which would allow for those applications which are pending before BSA or which have received approval before BSA to vest, in essence, their right to continue pursuant to the special permit, because indeed, if the community board is successful and the amendment is passed, why should we hurt Brooklyn residents who have already put time, money, expense, and care into enlarging a home for their family? And so I'm happy to answer any questions.
Questions for Mr. Lobel? Commissioner Efron.
Thank you, Mr. LaBelle. Are you representing any of the 4 applicants?
Our office represents 3 of these applicants,
Thank you.
including, I might add, one that has received the approval of Community Board 10 for their adoption, for their special permit.
Mr. Cantor.
Good morning, Richard.
Good morning.
You say you've been in long involvement with this process at the BSA.
Correct.
Would you know of all the applications for that went before the BSA, how many of them were actually executed in the manner in which you described, namely as fixer-uppers or add-oners for families, the way you described the original intent?
I can speak to my personal experience, which is that the homeowners who have sat with me and have applied for the special permit were not speculators or those seeking to sell enlarged homes. Those were individuals who wanted to enlarge the home for their family and indeed were living in those homes. I understand that the community board has alleged that there are certain individuals who may have taken advantage of the special permit. To my experience, that has not been the case, although I don't have any specific numbers to give the commission.
But with your own personal experience, those parties who you represented all did as the intent of the resolution existed?
Correct.
Thank you.
Any other questions for Mr. Lobel? Thank you, Mr. Lobel.
Thank you, Chair.
Is there anyone else who wishes to be heard on this matter? And hearing none, the hearing is closed. Thank you.
Borough of the Bronx, calendar number 17, CD5, N170027, PXX. A public hearing in the matter of a notice of intent to acquire office space for use of property located at 1775 Grand Concourse for the administration for children's services.
First speaker is Dale Lazarson from DCAS. Welcome back, Ms. Lazarson.
Thank you. Good morning, Chairman Weisbrod, Commissioners. I am Dale Lazarson with DCAS Asset Management and the Leasing Group. I am here to present and state that we are in favor of the proposed acquisition in front of you, which is a 195 notice of intent to acquire office space, as described by Justin Lamorella on Monday. Thank you, Justin. The space will be used for the Administration for Children's Services, ACS, and following the Allison grant, a representative from the agency is here to speak and answer questions about the agency's operations, which are currently located at another site in the Bronx, under a lease, which is scheduled to expire in early 2018 and currently does not have any opportunity to renew. So a relocation is prompted. The proposed space for ACS will be approximately 11,000 square feet. It will be improved to meet city standards as well as ACS standards, open planning, amenity rooms, etc. It is located in a private building that you heard described and illustrated on Monday at 1775 Grand Concourse. This is situated in the South Bronx in an area known as Mount Hope, which along with Mount Eden and Fairmont make up the neighborhood of Tremont. And a bit of trivia. I read in the 1800s a postmaster actually named Tremont because of these three communities all having Mount in their name. Back to the story. The building is 8 stories. This is including a lower parking level. This is comprised of 16 condominium units, 2 of the largest being owned by Verizon. The remaining 14 units are owned by a single owner who will be landlord to the city for ACS. And coincidentally is also going to be the landlord for City Planning's office in the Bronx, as well as the law department. So the city has 3 separate leases at this location, making up about 33,000 square feet of the building, which in itself is about 350,000 square feet. The proposed acquisition will be under a lease, a long-term lease for approximately 15 years with an opportunity to extend. May I answer any questions for you?
Any questions for Ms. Lazarson? Thank you very much, Ms.
Terrific.
Lazarson.
Thank you.
Next speaker is the aforementioned Allison Brandt, Chief of Staff of the Administration for Children's Services. Welcome, Ms. Grant.
Good morning. Thank you. Is this on? Yeah. Okay. Good morning, Chairman and Commissioners. It's good to see you again. It's been a little while. I'm here today to follow up my colleague Dale Lazarson from DCAS to say that ACS is here in support of the acquisition of the space at 1775 Grand Concourse for our Bronx resource area. I'm happy to take any questions. I'll give a very high-level overview of the work that we do there, just so try to forecast any questions you might have. We have about 18 staff at the space. It's used 5 days a week from Monday to Friday. We have security guards. We have about 40 members of the public on average there on a daily basis. The work that is done there is the checking of eligibility for subsidized childcare from residents of the Bronx. Other residents from across the city may go there as well, but it is primarily for residents of the Bronx. The great majority of our early learn contracted care centers are in the Bronx and Brooklyn, so this does service a great deal of families and children that are low income from across the borough, and we strongly encourage you to approve this so we can continue our operations. I'm happy to take any questions.
Thank you, Ms. Grant. Questions for Ms. Grant? Hearing none,
Great.
you are excused.
Thank you very much.
and,
Enjoy the rest of your summer.
I hope if this is approved, you will be a good neighbor to our distinguished Bronx Office of City Planning. Is there anyone else who wishes to be heard on this matter? And hearing none, the hearing is closed.
Borough of Queens, calendar numbers 18 and 19. Calendar number 18, CD 14, C160033ZMQ. Calendar number 19, C160351ZMQ. A public hearing in the matter of applications for amendments of the zoning map concerning the Seagirt Boulevard rezoning.
I just note that these are 2 separate applications. We will hear them both together, and the first speaker is Paul Pruill. Am I pronouncing that correctly, Mr. Pruill?
Good morning, Chair, members of the Commission. I'm here on behalf of Viteman Realty Associates, the longtime owners of the 2 parcels under consideration. Both are located on Seagirt Boulevard, approximately half a mile apart from each other. This started off originally as a single application for the 2 parcels in common ownership, but has been separated into 2 separate rezonings. Both are designed to activate and to develop these properties with commercial uses where commercial uses are not currently involved. The application ending in 351 is for Fernside Place, which is this intersection with Seagirt Boulevard here. And it is across the street from the only commercial uses on Seagirt Boulevard, between the Nassau border and the next several miles. So this is designed to activate this corner of the world with a single-story, 5,600 square foot retail outlet. And then there's also a proposed rezoning here from R4 to R5, which would allow another 10,000 square feet of development and facilitate a 5-story residential building, which you see here. The development of the site would look something like this, with parking underneath, parking in front of the retail outlet, and access to the retail off of Seagirt, access to the residential building off of the street over here, which is off of Fernside. The second application is, again, just slightly east of the site I was just describing, at the intersection of Beach 13, Hasten Road, and Seagirt Boulevard. This is across the street from Rockaway Beach and Boardwalk, where the city has just invested several $1 million in a new park there. The idea being that perhaps users of the park might shop here for conveniences, and that residents of the neighborhoods surrounding the site might have a place to walk to do some basic shopping. It would facilitate approximately 6,000 square feet of development, a single-story retail outlet with approximately 16 parking spaces. That's the proposal. These sites are currently underdeveloped, and with this proposed rezoning, we would hope to develop them with these uses and request your approval.
Thank you, Mr. Proul. Questions for Mr. Proul? Commissioner Efron.
Thank you. I have two questions of very different nature. One is whether or not you have retail tenants already with whom you're negotiating or would like to share with us the type of retail you're considering. And the other is, given the additional height because of the floodplain, could you just describe to us the notification of the residents directly behind those buildings who will be losing their view of the ocean?
Yes. So with regard to the proposed retail uses here, we did have some community outreach and interaction through the community board process, where we have made an agreement to keep them informed as we develop the plans for that site and the specific tenant. Right now, we're hoping for a kosher deli, which would reflect the characteristics of the neighborhood nearby and some of the input that's been provided in the outreach. Here at Fernside, we have spoken with the Deerfield Civic Association, which has provided us with a formal letter of support addressed to the department, of which I have a copy for you if you'd like.
I think it's already been distributed to the commission.
Okay, good. And the ask there is for something that's supportive of the community, that would allow for catering and some family dining. So that's the input that we've gotten. We've received that, we've listened to it, but we have not made a decision. We are currently speculative, but we'll bring this to the market once the zoning process is completed. And so that, I think, answers both the use question and the outreach. The outreach to the neighborhood was through the Civic Association. We met with about 30 of those members last summer, received their input and their support.
Thank you.
Any other questions for Mr. Proul? Ms. Ortiz.
Hi, just quickly, I note in the drawings, there's quite a lot of what's perceived as green space. I mean, what do you envision that being? Is it grassy? Will it be, there and on the other one? And
So directly behind this, there's a yeshiva where we've, again, spent some time talking to them, and they've asked for a little knee wall here to provide a little bit of privacy. We would envision that kind of wrapping around here, and then a landscaped tip here as you enter the neighborhood.
okay, so it wouldn't be active use. It's
No, this would just be landscape. It's too narrow to really develop with our use.
thank you.
Any other questions for Mr. Proul? Hearing none, thank you very much, Mr. Proul. Is there anyone else who wishes to be heard on this matter? And hearing none, this hearing is closed.
Borough of Manhattan, calendar number 20, CD 11, C160194ZMM, a public hearing in the matter of an application for an amendment of the zoning map concerning the 1968 Second Avenue rezoning.
First speaker is Richard Lobel. Mr. Lobel? Welcome back.
Thank you, Chair. Good to be back.
It's been all too long.
Chair, the application here is for an amendment of the zoning map, which quite simply extends a C15 overlay east of 2nd Avenue at 101st Street, such that the commercial overlay extends from its current boundary of 100 feet from 2nd Avenue to a new boundary of 155 feet. And this goes from 101st Street to the mid-block. The simple result of the proposed action will be to legalize an existing condition at a 2-story commercial building on the corner of 2nd and 101st, which houses a supermarket. This building was originally built in 1994 by a prior owner without permits. The building was afterwards reviewed by the Department of Buildings in 1995 and 1997, and was the subject of a post-approval amendment in 2000. So the building itself and the fire suppression systems, all the safety systems within the building were approved by DOB. However, upon subsequent ownership by the current owner in 2005, and upon subsequent application to the Department of Buildings, it was determined that certain nonconformances and noncompliances existed in the supermarket. Specifically, there are two. The first is a nonconformance such that beyond 100 feet from 2nd Avenue, although the commercial use extends 125 feet, the commercial district does not. So the proposed extension of the commercial district 55 feet would allow the commercial use to remain within that 25-foot portion. And the second one being a noncompliance, which is that there is a loading dock within that final 25 feet, and in order to comply with provisions of the zoning regarding adjacency to residential districts, the commercial district would need to be extended such that the loading dock could remain. The current application was actually previously an application before the Board of Standards and Appeals, applied for in August 2011. And despite the support of Community Board 11, signatures from 850 local residents, and testimony on the record from now Speaker Melissa Mark Viverito, the application was unsuccessful at BSA. Tough to get those variants sometimes. And so in 2013, that application was withdrawn, and we are now before the commission. Quite simply, this is a application which has fantastic support within the local area, the community board, and now the borough president. Within the local area, there are thousands of individuals who are served by this supermarket, individuals in multifamily housing who are in an area which has been identified by the department's own studies as being underserved by fresh food, and so this is a critical market for them. Community Board 11 approved this application by a vote of 37 in favor and none opposed and 1 abstention, and the borough president recently put her support behind this application as well. So quite simply, we're hoping that the commission follows suit and is able to support a modest application which will have a rather large impact in the community and in the provision of produce and healthy foods. Wow.
You're getting to be good at this, Mr.
Thank you.
Lavelle.
I'm trying. A lot of practice.
Questions to Mr. Lavelle? Commissioner Deluz.
Mr. LaBelle, thanks for that history. How much longer is the current lease with the supermarket for the space?
It's currently for additional 10 years.
Okay. And as you said, this isn't about redeveloping, this is just about compliance and
No,
conformance?
it's not. Quite frankly, the underlying R8A could be redeveloped with a large residential building, but to his credit, the owner has maintained this application and wishes to see the supermarket remain.
Any other questions for Mr. Lavelle? Thank you very much.
Chair, Commissioners, thank you.
Next speaker is Lucian Reynolds from the Manhattan Borough President's Office. Welcome, Mr. Reynolds.
Good morning, Chair Weisbrod, Commissioners. My name is Lucian Reynolds, and I'm here to speak on behalf of Manhattan Borough President Gail Brewer regarding the application to establish a C15 district within an existing R7A district to legalize an existing non-conforming use on a portion of property located at 1968 Second Avenue in East Harlem. I believe that the proposed zoning map change is appropriate, allowing a vibrant and needed commercial use to conform to zoning, and the proposed commercial overlay extension is consistent with the overlay district already existing on Second Avenue. In addition, given the development of the East Harlem neighborhood and borough-wide pressures on existing affordable supermarkets, it is important to support these existing businesses' efforts to remain, especially in underserved areas for fresh food stores. While this rezoning change will help this supermarket, it is clear that simply making the loading berth legal may not be enough to preserve this supermarket for another 20 years. The Fresh Zoning Incentive Program of 2009 can be a tool to ensure that supermarkets continue to be built and remain in perpetuity. I'm encouraged to see developers use this program in food deserts or areas that are nearly food deserts. However, this program needs to be made stronger to compete with development pressures and nimble enough to be applied in new areas. Food deserts are expanding, and new ones are forming as supermarkets enter into bankruptcy and encounter the loss of commercial space due to drugstore chains. Any expansion of the Fresh program must also include novel ways to preserve existing supermarkets, as today the program is focused on new buildings alone. We must entertain ways in which zoning can do more for all New Yorkers. Thank you.
Thank you. Questions for Mr. Reynolds? That's it, Mr. Reynolds. Thank you. Is there anyone else who wishes to be heard on this matter? And if not, this hearing is closed.
Borough of Manhattan, calendar number 21, CD 8, C160213, ZSM. A public hearing in the matter of an application for the grant of a special permit concerning 1290 Madison Avenue.
First speaker is Jeff Mulligan.
Good morning, Chairman Weisbrod and Commissioners. I'm Jeff Mulligan from Kramer 11 for the applicant. The application is a special permit pursuant to Section 74-711 to allow for the restoration and enlargement of a 6-story and penthouse residential building with ground floor retail located at 1290 Madison Avenue. The site is located at the northwest corner of Madison and 92nd Street. It's located within an R10 district and the Special Madison Avenue Preservation District. It's also located within the Carnegie Hill Historic District extension. The proposed project will slightly enlarge the footprint of the building to accommodate a new code-compliant elevator and stairways along this site's western lot line and a one-story service corridor along the site's southern lot line. A new 7th floor enlargement will replace the existing penthouse with the penthouse and bulkhead above the 7th floor that will be set back so that it's not visible from the surrounding streets. The enlargement will increase the building's floor area by approximately 5,000 square feet, and the total height will be increased from 89 feet to 95 feet. An extensive restoration to the building to its original historic design is also proposed. The Landmarks Commission issued a certificate of appropriateness for the proposed design in 2016. 4 zoning waivers are required to allow for the proposed enlargement: waiver of the height limit of 80 feet, the recess requirements along Madison Avenue, the side yard regulations to allow for an increase in the degree of existing noncompliance, and the inner court regulations also to allow for an increase in the degree of existing noncompliance. Community Board 8 unanimously approved the application on July 20th, and the Borough President also issued a recommendation for approval. And we're here to answer any questions you may have.
Questions for Mr. Mulligan? Commissioner Delauze.
Mr. Mulligan, in addition to the community board discussions, was there specific outreach to the adjacent property owners as part of the application?
Yes, yes. In fact, the immediately adjacent property is the Nightingale Bamford School. The owner of this building actually sold the adjacent townhouse to the school, has a good relationship with them. We also had testimony at the community board in support of the application from the Carnegie Hill neighbors.
Any other questions for Mr. Mulligan? Thank you, Mr. Mulligan. The next speaker is Erica Baptiste from the Manhattan Borough President's Office.
Good morning, Chair Weisbrod and Commissioners. I'm Erica Baptiste from the Borough President's Office, here to testify on behalf of the Borough President for the 74711 application for 1290 Madison. Standard to the Upper East Side and its mid-blocks, one finds what is fondly referred to as the historic donut, which is the agglomeration of the rear yards from the brownstones that typify this area. However, as a corner building with its predominant frontage on Madison Avenue, 1290 Madison or the Wellington, and the requested waivers for side yards and inner courts are consistent with what is also typical for the area. Corner buildings with extensive lot coverage and few to no side yards. What is also consistent with the neighborhood are handsome buildings along Madison that rise without recess and above the height limitations put forth in the special Madison Avenue Preservation District. The Manhattan Borough President believes the conditions and findings have been met for the requested special permit. It was more important to...
Sorry, Ms. Baptiste. That's because you're using such high technology here.
Clearly.
Far beyond the capacity of this room to absorb.
It's more important to maintain the building form for such a visible corner structure than to adhere to the permitted maximum height, which the building today... Oops. And I'm having technical difficulties. Already exceeds. While the vertical enlargement and infill in the existing non-conforming rear yard increase the degree of non-conformance for the existing building, it does not do so in a manner that will significantly impact light and air for the adjacent buildings or neighborhood. In addition, the applicant has also proposed a first-class restoration of the building. The proposed cornice reconstruction and other significant facade work and window restoration will ensure this visible building remains a contributing structure to the historic district. The inclusion of a historically appropriate cornice will improve the building and will further reduce the presence of the addition. The only item in the proposal that gives pause is, given the age of the building and number of units at certification, whether at any point such units were under rent regulation. Therefore, the Manhattan Borough President recommends approval of this application.
Thank you very much, Ms. Baptiste. Questions? I think this may be precedent setting. We've had laptops, we've had iPads. I think maybe the first time we've had actually an iPhone.
Well, I'm glad I could
So,
contribute to it.
we always like to push the envelope.
Yeah.
Thank you very much.
Thank you.
Is there anyone else who wishes to be heard on this matter? And hearing none, this hearing is closed. We'll take a very, very short 2-minute break before starting the next hearing.
This is right here already.
Okay. Okay, we're going to get started.
Ready?
Yeah.
Okay. Borough of Manhattan, calendar numbers 22 through 27. Calendar number 22, CD2 N160308ZRM. Calendar number 23, C160309ZMM. Calendar number 24, C160310ZSM. Calendar number 25, C160311ZSM. Calendar number 26, C160312ZSM. Calendar number 27, C160313ZSM. A public hearing in the matter of applications for zoning text and zoning map amendments and for the grant of special permits concerning 550 Washington Street, Special Hudson River Park District. Notice, excuse me?
I'm sorry?
I have a notice.
Go ahead.
Notice, a public hearing is also being held by the City Planning Commission in conjunction with the above hearings to receive comments related to a draft environmental impact statement. This hearing is being held pursuant to the State Environmental Quality Review Act and the City Environmental Quality Review.
Thank you, Madam Secretary.
You're welcome.
In addition to considering the ULIP application before us, today's hearing also functions as a significant action public hearing for the Hudson River Park Trust regarding the proposed transfer by sale of 200,000 square feet of unused development rights from Pier 40 and associated actions. Someone? Thanks. The trust governing legislation, the Hudson River Park Act, established the significant action process to allow the public an opportunity to review and comment on a proposed significant action within the park. For the record, on July 20th, 2016, the trust published a notice of hearing and public comment period, along with links to the proposed purchase and sale agreement and appraisal in the following places: the trust's website, the City Record, the New York State Contract Reporter, the New York Post, and the Villager. The notice was circulated to Community Boards 1, 2, and 4, to the City Planning Commission, to the Hudson River Park Advisory Council, to local elected officials representing communities neighboring the park, and to other interested community leaders, neighbors, partners, and organizations. While concurrently held, the Trust's significant action hearing is distinguished from today's hearing on the ULIP applications because the Trust has no jurisdiction related to either the creation of the Hudson River Park District or the proposed private development at 550 Washington Street. Instead, the significant action by the Trust under public review relates to the proposed transfer of 200,000 square feet of unused development rights from the park if the land use actions, including the special permit, are ultimately approved by the city. The Trust has negotiated a draft purchase and sale agreement with the developer of 550 Washington Street property for the transfer pursuant to which the developer would pay the Trust $100 million. The Trust also retained an independent appraiser to conduct an appraisal of the subject development rights and has identified the infrastructure improvements it would make to Pier 40 in compliance with the Act and special permit requirements. The full text of such materials is available for review on the Trust's website and at their offices at Pier 40 on West Street. If the ULIP application actions are approved by the city, the Trust directors would vote to consider the sale after also considering the public comments received during the significant action process. Copies of the Trust public notice are available at the sign-in desk if anyone needs a copy. Please be advised that the public comment period for the proposed development rights transferred by the Trust will remain open until September 21st, 2016, and that comments received today are being transcribed by a stenographer. These oral comments will receive the same consideration as any written comments that are submitted during the review public comment period, which has been open since July 20th, 2016. Pamela Frederick, who is sitting behind us here, a member of the Trust Board of Directors, is serving as the Trust Hearing Officer for today's joint hearing. Welcome, Ms. Frederick. She is joined by the Trust President and CEO, Madeline Wills, and by the General Counsel, Amy Jedlicka, Chief Financial Officer, Dan Kurtz, and Executive Vice President, Noreen Doyle of the Hudson River Park Trust. Now, before we begin our hearing on this matter, please note that what our process will be. The applicant team will provide a 15-minute presentation, which will be followed by questions from the commission. That presentation will be followed by 2 speakers from the Hudson River Park Trust. We will then have 5 speakers in opposition who will be given the opportunity to conclude their testimony before the next 5 speakers in favor are heard, and we will rotate back and forth between 5 in opposition and 5 in favor until all those who wish to speak have been heard. And the hearing will proceed until all speakers have an opportunity to testify. And if an elected official comes who wishes to testify, that process may be interrupted as a courtesy to that elected official. But otherwise, that is the process that we will stick to. And with that, we shall begin. So we will begin with the applicant team. And will you please identify yourselves?
Good morning, Chair Weisbrod and Commissioners. My name is Michael Sillerman of Kramer 11, Land Use Counsel to the applicant. The proposed project today will be the first use of the development rights transfer.
Will you, before you start, Ms. Silliman, just identify the other members of your team, since you're here with a team?
Yes, so we will have Rick Cook, the principal of Cook Fox Architect, the designer of the project, and then we will have representatives of Alley King, Rosen, and Fleming to answer questions about the environment to the extent that those come up, and another member from Cook Fox. But we're assuming that Mr. Cook and I will make the main presentation. We won't have more than 2 speakers.
Go ahead.
Okay. The proposed project today will be the first use of the development rights transfer mechanism being created to provide critically needed funding for the Hudson River Park. And Pier 40 is shown on the first board, and the development site, St. John's Warehouse, is across from that. The project will include 5 buildings, show the next board, with a total of 1.7 million square feet, or 8 FAR on the zoning lot, including 1,289,000 square feet of residential floor area, 200,000 square feet of retail and event space, 220,000 square feet of office or hotel, an elevated 20,000 square foot public open space, and 772 accessory parking spaces. The project will provide $100 million to the Hudson River Park in exchange for the transfer of 200,000 square feet of floor area. The payment will help to save Pier 40, where 260,000 children and adults from around the city play every year. These development rights will be moved out of the park and across the street. The project will also provide 328,700 square feet of permanently affordable housing, equal to at least 25% of the residential floor area and at least 30% of the residential units in the project. The developer has worked closely with HPD to develop an affordable housing program that will include both senior housing and housing for both low and moderate income households. The project will create 800 construction jobs per year and 1,500 permanent jobs. The project has been designed by Cook Fox Architect, and the firm's principal, Rick Cook, is here today. The sustainable design will transform what is currently a barrier to the waterfront into an ensemble of buildings that allows improved access to Pier 40, visual corridors, new retail opportunities, and a public open space in an elevated garden above Houston Street. The total FAR of the project is 8.7 FAR, including the transferred floor area from Pier 40, which is less than the 12 FAR recently approved for the Hudson Square Special District, 1 block to the east, and similar to the 7.2 FAR permitted in the Tribeca Mixed-Use District, a few blocks to the south. The project has also been designed to be consistent with the maximum heights permitted in Hudson Square. Indeed, the proposed actions will update the antiquated zoning still in place on the site and bring the zoning in line with the commercial and residential development trends in the neighborhood. The requested actions for the project shown here are a rezoning of the development site from M15 to C64 north of Houston Street and from M24 to C63 and M15 south of Houston Street, which were shown on the prior board. A special permit to allow the transfer of 200,000 square feet from Pier 40 to the St. John's site, and to allow certain bulk waivers to allow the proposed buildings to fit better into the neighborhood context. 3 parking special permits to allow 772 parking spaces in 3 separate garages, 3 curb cut authorizations to allow curb cuts on West Street to access the parking garage, and a chairperson certification to confirm that a payment plan is in place for the purchase of development rights from the Hudson River Park Trust. Rick Cook will now describe the project in more detail, including changes made in response to comments received from the community board and the borough president. These changes include modifying the design of the through-block passageway to make it more pedestrian-friendly, adding lighting and improving the pedestrian experience along Houston Street, and agreeing to explore with State DOT a new crosswalk across Route 9 at the location of our through-block passageway. At the conclusion of our presentation, the project team is available to answer any questions.
Thank you, Mr. Silliman. Mr. Cook.
Thank you, Michael. Thank you, Commissioners. Thank you, Mr. Chair. And I also want to thank everyone who's been involved in this amazing project. There's been an incredible amount of time and energy from the community board, from the public, from the borough president's office. And Mr. Silliman spoke a little bit about what we're trying to accomplish and how we intend to accomplish it. I'll start quickly talking about the why. Why are we passionate about this project? Why is it something that we care deeply about? Also, this is Simone DeCono from my firm, who will be moving a lot of boards very quickly and try to meet my time schedule. First, it's clear the motivating factor for the project is to save Pier 40 and the remarkable resource that is as active play area for our community and for our city. The second, and very motivational to an architecture studio, is creating permanent and high-quality affordable housing. And then from a planning point of view, a very significant issue is breaking the super block. This is an 850-foot-long obsolete infrastructure building which blocks us from our waterfront, from Pier 40, and from the river. After that, the street level experience is horrific in the location, and the intent is to radically improve the streetscape experience, the retail continuity, and everything that goes with that. And then lastly, we had the opportunity to create something that is a completely unique, publicly accessible open space that serves a series of purposes, not the least of which is an amenity for our affordable seniors. Okay, so I'll go through a series of boards quickly, and Simone will help. Our very first goal, much of our work has been in landmark districts where architects, that we look at blank slates, and we see empty sites, and we envision buildings that we think would be good there. This site is exactly the opposite. There's been a building in the way blocking us from the waterfront on Houston. So sometimes I've gone by parking lots and thought about the building, including around here on the corner, that could be there, that would make our city better. This is a building that I wanted to go away that would make our building better. So the very first sketch we ever showed on the project was to open up the end of Houston, connecting Houston to light and air that's beyond in the river. Beyond that, this building that's been there for 8 decades now was built in 1934 as part of the New York Central Railroad West Side Improvement District, what we now call the High Line. We thought we could do something very, very unique here, and that gauntlet that exists right now, that very dark corridor to connect us from the city to Pier 40 and the Hudson River Park can be radically improved. And we've been working in a series of incredibly informational and collegial working sessions with the community board to talk about the retail continuity that could happen along here on Houston. We're looking at the north side of Houston here, taking away what is the rail beds, the platform area of the rail beds, keep the historic rails, work with a lighting installation to make it something that's totally unique to this one spot and bringing daylight down to the street. If we look here, the board that's behind me is the first floor plan. The next really important part about breaking this super block, we were just looking at this gap. We were looking at this gap right here over Houston, removing the mass that's there right now, that's been there since 1934. The other area that we're breaking the super block is the difference between, this is between the north and the center site. Between the center site and the south site, we've been able to create this connection from West Street to Washington Street, which hasn't happened since 1934. Right now, what you're looking at is a barren wall of the existing building, and we have the ability to open up and connect that location from Washington Street all the way through, which is just south of Pier 40, and therefore would be open to the river and the open sky of the river. One of the things that came up in our discussions was that this really needs to be a real pedestrian experience and not something that's car dominant. So this image that you're looking at right now is from the sidewalk right here. This is what we call the Center East building, which is the mixed income building. And you're looking here to the Center West building and out to the water. So the idea is that the paving would be traffic calming, there'd be a beautiful sidewalk experience, there'd be benches, and this would be a welcome place for the public to connect from Washington Street to West Street. The other important corridor that right now is underutilized is a beautiful street called Clarkson. And Clarkson's somewhat dead right now. There's a construction project on on West Street and Clarkson. And right now, the kind of dead, no retail to the south of the existing St. John's terminal will be radically improved. What we're looking at in this view is we're on Clarkson looking towards Pier 40, and we're hoping that that crosswalk to Pier 40 will be much more active. This is a nice cobblestone street. This is a building called 160 Leroy, which is under construction right now, and this is our project directly across the street. And you can see that although we've asked for relief from the antiquated 85-foot high maximum street wall height, we've worked very hard to have a variegated street wall where the street wall brings light down to the street. It has a variegated elevation as you walk down the street. And then if we come back around to Washington Street, where we're standing right now in this view is this is Washington and this is Houston, and this is the entry into the mixed income building. That's the building that we call the Center East building. This is the entry into that building, all of the amenities completely integrated, all of the units completely integrated in the affordable building. And this is the access up to the publicly accessible open space. This one place has the ability to have an authentic condition that references the High Line. And you're standing, in a minute, you'll be standing right here. So we're coming up to the second floor. On the first floor, it was important to us that we had neighborhood scaled retail, and we've been talking to the community about that. But we also really want to create a grocer. And the best way to do that was to come up and create the grocer, the large scale retailer, as a neighborhood amenity in a place where it wouldn't create dead street level activity. So we brought that up to the second level so that the grocer is on the second level, feeding out into the publicly accessible open space. And this image that you're looking at here in the center is right here after you come up the stairs of the elevator, looking back across the opening down to Houston, that view we had before. The grocer that was planned to be a grocer is here, and the senior amenities are immediately adjacent to it to the right here in this image. The next image will be in the center portion, right here, the largest area where the historic rail beds still exist. And that creates a place here. All of these get this unique view back down into the city on Houston and back out to the river. So you're standing right here. And the next one will be standing right here at the other end. So where we've had this big barrier, this big wall to the park, all of us, all the public, and all 4 residential buildings will have access to this area, including this view, which is taken by sticking our head out a window from the existing building. So this is something that's available to the entire public. We view this publicly accessible open space as the great connector for the project. But very importantly, from the early days of deciding what was the appropriate permanent affordable housing, it was the dramatic need for senior affordable housing. And we viewed this publicly accessible open space as a really kind of wonderful amenity because it allows interaction with all 4 buildings and the public in a very safe condition off traffic. So if you look at the way this is set up, keeping these existing rails, there's actually an 1/8 of a mile walking path surrounded by retail that's feeding out onto the 2nd floor. The image directly behind me is from the senior amenities, which is right here, looking right back out here. So this image that we have here is from the senior amenities on the 2nd floor, looking back out across the 2nd level publicly accessible open space over to the mixed income building directly across from it. Another issue that came up that we've been working with, this is a 5-building complex where there's now this giant beast of a infrastructure building, and how to mass the building so that all of the component pieces have beautiful views. It's just an incredibly beautiful site. So the senior affordable housing, we want to do this view. This is a corner unit right here, what we call the northeast building, looking right here, which has beautiful open views towards Midtown. Okay, very quickly. Also, from this point right here in the mixed income building, this is a view back out past the commercial building, past this, out to the water.
1 more minute, Mr. Cook. I'm
Okay.
sure there'll be a lot of questions.
Okay. And then ultimately, in a 1-minute wrap-up for this project, we intend to create a diverse, healthy, and sustainable waterfront community where there's now a monoculture of this infrastructure building, replacing the obsolete zoning which allowed an unlimited height tower for something that's been crafted with community input and dialogue. And then ultimately, we needed a passion about why it should look the way it does. There's very tall street wall buildings, forms inspired by nature, and that tallest building looking from the north to the south. Thank you very much, Commissioner.
Thank you very much. Okay, it's open to questions. Commissioner Delausse.
I'm sure you all have read the nearly 15 pages of comments from the community board about the project, and in particular, I guess I would want to start with the rationale used to locate the height more in the northern section as part of the process. And then I just have a question also about how the AMIs were determined on the affordable housing so far. I'll come back for more questions.
One of the principles about locating it there, and then I'll let Mr. Cook expand on this, is a planning principle that I think it was fundamental to the department to recognize that this is still a mixed-use district, so that the southern portion of the site, which butts up against the Spring Street sanitation facility, remains manufacturing M15, and that Washington Street it has the very important UPS distribution center across the street from it. So there was an intention here to not activate Washington Street and to have the entrances to the north and to have the bulk to the north. And I must say, even going back in history, I think that there was a recognition that the block north of Houston Street could be rezoned and used residentially. And you know, we think that in Hudson Square, the tallest buildings are along Houston Street. So that was the intention there. There was I guess, a pretty fundamental difference in view between us and the department and the community board on that. And then,
Sure. The decision on how to mass the building, I think in part is directly related to the work that was done by this commission on Hudson Square, in that there was a 290-foot height limit typically with a 10 to 12 FAR, and one special site known as Duarte Square at 430. So that background issue of the recently completed zoning was absolutely out there. Then the next step was that we had a waterfront condition. So we had the kind of 1976 Saul Steinberg view of the world from 9th Avenue. So we're open all the way across the river. It's the widest avenue we could possibly have. So then the next move was clearly height along with the widest avenue, West Street, the river, and the openness that was there. Second component was that Houston is clearly the strongest height corridor coming across. So the tallest building should be both on West Street and on Houston. And the immediately adjacent neighborhood is filled with some very tall street wall buildings that then start to step and mass. So it was really down to West Street and Houston, north or south. And the thought was that we would step the massing down and tie into the Department of Sanitation building, which has been recently extremely well received. We have the salt shed, we have the Department of Sanitation, and it seemed to make a kind of elegant massing composition and take some of the pressure of the residential use off of the southerly portion immediately adjacent to it. That was also consistent with the fact that the proposed actions include keeping an M district for the southern site, so that southern site was also a barrier. So there was an overriding idea to continue to buffer and transition from the Department of Sanitation garage and the manufacturing district to a manufacturing zoning on our site into residential, and we thought it could be a beautiful, elegant building at this location. Thank you.
Thank you. I think there was a second part to Ms. Delus's questions.
There was just about how the particular options were chosen on the MIH piece. And then, since I have you, I guess the other question I have really was about one of the criticisms in the proposal from the community board of concerns was about the parking, the number of parking spaces, if you could address that. And then maybe outline the different sizes of retail, because there's obviously a concern also about potential big box.
Okay.
Sorry to continue to add, I will stop there.
I believe that's a four-part question that is actually gotten the maps very disturbed, but.
Okay, so the AMI levels and the distributions were developed in consultation with HPD, and we really kind of followed their leads and their priorities. The senior site is at 80% AMI, and then the center site, which is a 50-30-20 building. It's 50% market and 50% affordable. 20% of that is at 60% AMI, and 30% is at 130 AMI. And I think what happens as you go through the land use process is that there are a variety of views about this, and we expect to have a consultation about that. But that really wasn't, I would say, in fairness, driven by us. That was reflecting an administration and HPD priority.
The other question was just about walking through the sizes of the retail space and the parking, the number of parking spaces, because there's concern about that as well.
Okay, so let me start on the retail space. I mean, remember here that this is a 1.7 million square foot site, and it's a large site, and the intention here was to allow expanded opportunities for retail and to have some opportunities for synergism of what you would want to have. For example, adjacent to the park, maybe you want to have a big sports equipment facility. Mr. Cook can take you through the retail plans, but you will see that other than for the market on the second floor, which we think is an important energizing and amenity component for the affordable and for the seniors, I think that they are not large spaces, and you know there's kind of a tension here, because you're saying on the one hand we have a concern about the size of the retail, but on the other hand you want to energize Clarkson and you want to energize Houston Street, and that was the intention. We think it was carefully thought out. So can you take them through, please, some of the retail?
If we look at the board in the center, we were trying to create enough breaks in the architecture and the planning that the component ground floor retail uses were of a more neighborhood scale. So if I start here on Washington and Houston, there's the entrance into the grocer that's right here, then the senior housing lobby. We have a retailer here and here, then the residential entry, a retailer up on the corner. That's 17,000. The retail in the corner here is 4,800. This is 48 on the corner, and then 24,700 along Houston, which we think is important to activate Houston Street. Directly to the south, on the center site, there's a retail of 19,000 square feet and 21,000 square feet blocks that could be broken up into sub-tenancies. The idea being that any really big retailer would be up on the second floor, so we wouldn't have our streetscape ruined by back-of-house things. So that's the image that's here, here behind me. The largest retailer is on the second floor, so that the active side is here on the publicly accessible open space. You actually arrive by escalators or elevators from that corner piece below. So that's kind of the framing element when you're approaching from the east. We had a very small retailer, 2,300 here, 4,500 here, broken up by the two entries from the residential buildings out to the publicly accessible open space, and then a retail or cafe that we hope would feed activity out onto the second floor open space also. So those retail components were crafted to have diversity and street level activity.
What's this size of that second floor large retail?
The large
That
retail is
space?
40,000 square feet, the one that we intend to find a grocer for.
And then I think Ms. Delos also had a question about parking, and then we'll open it up to other commissioners.
Yes,
Although I'll come back to Ms. Delos, I'm sure.
I think also the design of the retail, that in a large project like this, until you're actually out there in the market, there is a desire from the applicant's point of view to not be straitjacketed and to have as much flexibility. And I think historically, some of the special districts that the planning department used to impose, which kind of micromanage the size and the kind of retail, ultimately weren't successful. So we intend this to be service-oriented or to synergize with the pier, but we'd like to retain as much flexibility. With respect to the parking, where there's a request for 3 separate special permits for a total of 772 spaces, which complies with the Manhattan Core methodology to not provide more than 20% of the demand in the district. I mean, I would say that it's not quite Rashomon, but I think that there's a very radical difference in perception between residential tenants, whether they are renting or buying a unit, and the amount of parking they want, and the perspective perhaps from the department or perhaps, and certainly from the community, that residential apartment owners want a lot of parking. I mean, they want 100%, or some of them have more than one car. And here, we've asked for 772 spaces based on 1,500 units. And even to anticipate a question, even if you take out the affordable, it ends up being, I think, 69%. And it's an important component of the marketability and the desirability of the market rate units to provide that amount of parking, particularly on a site that is relatively remote. It's on West Street, and it's a quarter of a mile from the nearest subway station.
Commissioner Efron, followed by Commissioner Ortiz.
Thank you. Thankfully, Commissioner Delauze began the conversation on some of the points I had, and I apologize if this feels all over the map, but I think we were quite clear in the review session that we expected you to come prepared to answer a lot of these questions proposed by the Community Board and the Borough President's recommendations and resolutions. And there's some new points raised as well. In looking at the large size of the retail units and the public space on the second floor, all of a sudden here, and I'm not characterizing this negatively, it looks as if that section of the north side of the building with some of the center really is very much a mall atmosphere, and the public space on the second floor is really a second ground floor entry for the retail. I understand that it's adjacent to what would be the senior amenities, though those haven't been defined. But I wonder, is that space off of retail hours going to be attended? Is this something that seniors will really benefit from, or is this considered access to second-level retail? And similarly, the parking, which you've referred to as 69% for, or the ratio is 69% for the non-affordable residents. What do you anticipate the usage being for the retail users, since one of the concerns of the community board has been additional car traffic to these very large size retail locations? That's one tangent. And I hope that was clear. And then I have another question around the affordable units and their location. And this diagram is incredibly helpful on the proposed buildings. So as I understand, and I hope you'll correct me if I'm wrong, the blue is market rate housing. The yellow is what you're considering mixed income housing. And the orange is senior affordable housing. Is that right so far? Of the mixed use in the yellow building, how many units are market rate and how many are affordable?
The mixed building, the affordable building is 50-50. It's 50-30-20. 50% market and 30% at 130 and 20% at 60. So it's half and half.
Okay, and then how many units are in the proposed in the market rate, in the total blue?
I'm not sure. We'll
Okay,
have to
it would
give
just
you
be
that
useful
number.
to understand it, because I think some of us are concerned, as referenced in the two reports, about the allocation of market rate in the desirable locations, that the affordable and the desirable locations of the market rate.
Yeah, no, understood, and I think Mr. Cook can address to you that the east, the 50-50 building was carefully designed to retain views of the river in a good way for those things. I mean, remember that this is a 5-acre complex, and there are 5 buildings on it, and, you know, they're separate entities. Certainly, in the affordable building, it's shared amenities, there's no pour doors, and it complies with the mandatory requirement that there be affordable units on 65% of the floors.
Can you go back to, we'll try to go back to Commissioner Efron's first question.
Yeah, so about the...
And I would just ask, it's very, very detailed and complex project, so I would ask you to separate your questions so the speakers can respond to each question as opposed to trying to remember a 20-part question.
That's fair, and I apologize. It was a very
So-
complex question, but really it's a question about the parking and the size of the retail.
Okay, so on the size of the retail, I mean, I'm surprised that it's characterized as a mall. I mean, New York doesn't have many malls. This is not Time Warner, which is probably our one high-end mall. I mean, the spaces here, other than the grocer, which is...
Well, there is the World Trade Center now. I just point out in Lower
Yes,
Manhattan
all
that
right.
it's now opened
You
up,
know,
so
I'm a child of
as
the
a
60s,
Lower
so
Manhattan advocate, I just
Yes.
want to recognize that
I don't
we
think
just
in
don't have
present
one
time-
mall in
Mini mall seemed inappropriate entirely, but.
Right. No, but, I mean, the spaces here, there's a retail cafe of 10,000 feet, and then it's, one space is 4,500 and one is 2,300, and it's intended to energize that space up there. And, I mean, can you talk a little bit more about the intention, how you expected this to operate?
Yeah, I will. Sure. I think for us, I couldn't disagree more about the mall issue, even if Lower Manhattan does have a very expensive one right now. These were all intended to be street-level storefront. That's what it was about. We have, the site itself is enormous, and it has no street-level activity at all. So the idea was to have corner retail, corner retail, corner retail, and corner retail, and fill it in, to activate the street, to make it a pleasant place to be, the same on the southern side of the street. Then the trick, the real puzzle that needs to be solved is how is this one unique publicly accessible open space that's viewed as an amenity for the seniors, how is that activated? How do we make sure that's a pleasant place? So what we did on the second floor was propose that the one larger retailer that we thought was good for the community was well received as the intent to have a grocer. Those grocers tend to have back doors and front doors, and that would have ruined the streetscape. So we have that up on the second floor with the entry from the first floor up, so that the back of house is on the second floor and the windows, and the front of house is looking out on the open space. And then we had both the seniors opening here, and we have both other residential buildings and the fourth residential building all activating that space, as well as having the public come up there. The 3 other retailers are really intended for activity for the publicly accessible open space. So I would say, first, it's street-oriented, pedestrian-focused retail. It's not interior at all. And then the second thing is it's a very unique thing that we're proposing. It is a authentic fragment of something that happened that we now kind of know and love from the Whitney North at Gansevoort as the High Line, and this piece is here. It gives us remarkable views back down to the city and out to the river, and the retail is really there to activate it. We made sure that the other buildings also came out, and we view this thing as the connector between the public and the 4 residential buildings.
Parking.
The other thing, while I'm here, I can shift to the other question also about the location of the affordable components and the relative views. Would that be okay? I'll shift to that one, or should I have my?
Yes.
Can you respond to Commissioner Efron's parking question?
Is there designated parking for the retail? Is there access from the parking to the retail? Is the intention that the parking would be for the retail, or is it only for the residential use?
Well, I mean, this is a special permit for accessory parking, so that means that it's available to the residents, the employees, and the guests and the users of the retail. I don't think that there's a particular allocation of retail spaces, and can you talk about operationally how you'll access the parking if you shop?
The same stairs and elevators here, the stairs and elevators which access the publicly accessible open space also go to the parking level.
Commissioner Ortiz.
Hi. So along the lines of the retail, I wondered if you could speak to the merchandising plan. I mean, there's a difference between the kind of retail we might call neighborhood serving, the kind of retail we call destination and big box. So my understanding is that there, with the exception of a few spaces that are 2,500 square feet, that the average are at least 5,000 or more. What kind of retail do you find tends to occupy spaces of that size? And what is your plan, given that you've designed the spaces of that size?
I'm not sure that's fully known at this point in time. I mean, obviously, you know that one knows that in a complex that has 5 buildings and this amount of daily population, that you'll need a certain amount of local amenities, drugstore, cleaner, pharmacy, that kind of thing. You know, I'm not sure that in a project like this, that there is that specific a plan about how it will operate, other than saying these are by their configuration, and because they're split by lobbies and access to the open space and so on, that, you know, by definition they can't get too huge, and there is an intention to try and do things, as I mentioned, that reinforce the Pier 40 kind of population, so that there's a notion that it might be good to have sporting goods or those kinds of things. But I think it's to some degree, you know, a work in progress and hard to know at this point.
Well, I guess the question is, you know, these spaces at 5,000 square feet or more tend not to be occupied by, say, a dry cleaner, for instance, or, you know, 10,000 square foot restaurant is really quite large. It's not perhaps intended to be solely neighborhood serving. I understand that you're looking at potential Pier 40 in the Hudson River Park, and one of the issues that has been raised is that, and certainly something that we're looking at, is different kinds of retail generates different kind of parking. So these things are connected, and we would like to understand the extent to which you're anticipating the kinds of retail uses that will generate more parking versus less.
Right, and I mean, from the market perspective, I don't think that 5,000 feet is considered a large space. It may be bigger than a dry cleaner needs, but you know, it's certainly not, I think, sometimes much too loosely used term, a big box. I think our environmental analysis, as I understand it, did take a very conservative analysis in assuming that a high percentage of the retail, and I think probably more than it will be in reality, was destination. So we built that in, and we can provide that backup to the commission subsequent to the hearing.
Commissioner Cantor.
Thank you. A couple of questions, Michael, and maybe I guess Rick will come in too. How does one park and get into the store, get out of the store, load the car?
Two parts to the answer. One, I think when I described the architecture and how the spaces were broken up, those spaces can still be subdivided to smaller scale retailers. That's the maximum size they could possibly be based upon where the lobbies are. So on the retail, I think the applicant would love to engage with the community and have a healthy, vibrant retail mix. When I spoke, I mentioned about, I should have said, that's the largest possible size any one retailer could be in that area because of the way the architecture is developed in the lobbies, so they could still be divided into smaller. The one larger scale retailer was the grocer on the second floor. For me, I envision the West Street would be broken up into smaller, maybe even connecting from the ground floor up to the second floor also, and that would be another way to provide some more activity on the second level. So that's wrapping up that one, kind of related. As you know, the building right now is a giant, long, linear loading dock facility with lots and lots of curb cuts. So we've planned a series of specific curb cuts to get down into the parking, and that parking is connected to those two elevators that we showed that are related to the publicly accessible open space. So the hope is that people would have those. I don't have the cellar plan with me, but there's one entrance into a parking here, and there's one into a parking there, and there's one into the parking there on the southern commercial site.
Excuse me, how does the lowest level of parking relate to the floodplain?
The entire project, the sidewalk level, and it's actually important related to the retail, the ground level, the sidewalk, is below what's called the design flood elevation. So the project is proposed to be what we call dry flood proofed, which allows the retail to exist at the sidewalk level, which was an extremely important component of the planning of the project from the beginning. So we are planning for the project to be dry flood proofed so that we can have retail at the ground level. The cellar is fully in the floodplain and will be dry flood proofed. The cellars are connected. On the north site, there's a cellar that connects both what we call the northwest building, the northeast building, into one parking that connects to the elevator here. In the center east and center west, there's one connected cellar that connects to that same elevator. And then on the south building here, there's a separate cellar that connects to a small elevator and entrance lobby off of West Street.
But virtually everything is below the floodplain at street level.
Yes, yeah, the sidewalk itself is depending on where you are on the site, somewhere between 6 feet and 7 feet below what we call the design flood elevation.
Rick, have you guys as yet done a traffic study?
Yes, and
Part of the EIS?
DEIS as part of the ULERP process. Significant, and the gentleman who prepared the traffic study for the DEIS is here also to answer questions.
And to continue, the open area between the two sets of buildings, is that intended at grade? Is that intended to be passive seating or what?
No, this is, the area that's called the landscape roof is basically a green roof like our office. And it's just an open space like any internal courtyard to a complex, a rear yard, backed up rear yards. So that's a landscape roof. There's no access for anybody to that. It's purely a garden, and it provides light and air. The public circulation is through here.
Well, my question was leading to light and air. It seems to me that the sun hardly ever gets to that area.
Actually, we're blessed with our solar orientation, in that south is down this way on this image. So we've done extensive solar studies. So there's actually quite good. And the one thing that doesn't come across is how narrow the massing tapers up to, how narrow it tapers here and here. The buildings are actually very, very narrow, much closer to some of those Jazz-A skyscrapers that have the very small footprint at the top, as opposed to the big slabs that we tend to see. That's all right. That's all right. Sorry. And it's okay. Thank you. And I just actually want to make the point about this. Part of that was making sure that all 5 buildings had beautiful views. So, for example, that image that's down by Simone's foot there is an image taken from the building that's to the east. And the idea is that we've held the massing for the Center West building down here. So this side of the Center East building, the mixed income building, looks out over it or by it. So that view out to the Statue of Liberty is from this building that's to the east. Likewise, the senior affordable is an incredibly high quality building. It has terraces on the 10th, 11th, 13th, 14th floor, all terraces which have views of the river and a really beautiful view up to the north. I'm not sure how I got to all that from your question, but that...
You got there cleverly. So why don't we do a second round? We can come back to Commissioner Cantor. Commissioner Ortiz.
Hi. So on the parking, if we could dig in a little bit to understand this, one of the questions I ask is, why do you think you need 772 spaces? You know, these uses, what evidence do you have that these particular uses require this level of parking to succeed? And I do note, you said, you mentioned the marketability of the units, but then, keep in mind you're effectively exhausting the share, this 20% share, so no other developers after you will be able to use that argument. And it's not really our job to encourage car ownership. In fact, we want to encourage, walkability, and we don't want to induce demand by creating parking. So, I really do want to understand why 772 is the right number.
Okay, so first, as I said, I think that the residents of this building will demand parking, and if there isn't a healthy percentage, it affects the marketability and the finances of the project. I mean, I'm not sure that I really understand the Manhattan Core parking methodology. I know that the commission had a presentation on it, but as I understand it, there's a target which says that you can have up to 20% of the demand, and I don't think we haven't looked at and seen whether other projects have gone up to that percentage or not, and we can look at that. But the point is that it's a shifting analysis, because the core analysis is based on within a third of a mile of your site, so that any new building has a different catchment area and analytic area, and it shifts over time, so that that the new building, first of all, will create demand, which is factored into it, number one, and number two, it will include within its area any parking which has been diminished in the 10-year period, and it will include any other buildings that don't have parking provided that were built within that area. So, I mean, I think it's speculative to assume that this is foreclosing other users of it. But that is the methodology that the commission has adopted. And
Let me just say, Mr. Silliman, if you go a deep dive into the Manhattan Core parking requirements, we'll be here till next Tuesday. So I would say that, just to respond to or further what Commissioner Ortiz is saying, is that at least for a period of time, if these 772 parking spaces were approved, it would put a pretty hard cap on new parking spaces for new developments in this immediate area. And without going into
But I also
exquisite
don't,
detail about it, that
yeah,
that would be in fact the
so,
result.
you know, you still didn't answer my question. Why do you think you need 772 parking spaces? I mean, my understanding is that car ownership in fact declines when we have dense neighborhoods, and people, and this is Manhattan. You know, this is still the core of Manhattan. There's a reason why we have these particular restrictions on parking.
I think talking about it globally doesn't necessarily advance things.
No, I'm talking specifically. I want to know specifically
Yeah,
about this.
no, I think that these kind of, that there will be demand by the market rate renters and the market rate buyers, if there are condos here, that is at least that much. They want that. I think that this is a site which will probably attract a population that finds it useful to be right next to West Street and to be able to get on the highway. And this is not in the middle of Manhattan where you know you're on Union Square and you have many transit options.
Commissioner Delauss, followed by Commissioner Efron.
Just a couple more questions. If you guys could talk a little bit about the commercial loading and how that's handled, because obviously, you know, the commercial spaces are in multiple buildings, and especially with the potential 40,000 square foot supermarket, that's potentially significant. Also, if you could talk a little bit about the intention around construction phasing, that would be helpful. Any sustainability features you want to highlight. And then I just wanted to point out, going back to Commissioner Efron's question earlier, I'm assuming that specific to the 50-30-20 and the 100% affordable senior building, I'm assuming that each of the buildings is underwritten separately, and that's the reason that the affordable units aren't dispersed among the 5 buildings, but just in the 2 that are highlighted.
Okay, so.
Loading, phasing, sustainability.
Okay. On the loading, starting from the south, working towards the north, the commercial building, right now, there's a little gap between the Department of Sanitation building and the existing St. John's building, the little service alley. So we're maintaining the curb cut there, and we have a service alley to support the commercial building, which is whatever M District allows. Hopefully workplace of the future. It also would allow a hotel. So that takes care of that one. On the center site, the thought is that this newly created connection between the Washington Street and West Street allows for a version of off-street loading for the building also. There's also for smaller connections, we now design all below-grade parking for accessible vans, so that allows smaller trucks to come down. And these are both these buildings are 2 core configurations, so that it can be lower in the center. So that allows service for Center East and Center West that goes down a parking ramp to actually do that and connect to their service elevators. And then to your specific question about the retailer, there's a dedicated loading dock right here with a dedicated elevator which services that use onto the 2nd floor and also provides a connection at the cellar level. That is the service. The second was?
Phasing.
Phasing.
We're going to try and limit the questions to 3 parts.
One of the things that happened since we started on this project, a name affiliated with the previous administration was the tenant for the entire south, portion of the building, and it was encumbered with a lease. In this process, that's been negotiated so that the project will be coming completely vacant. This building that's been encumbered with leases for a very long time is becoming unencumbered by the leases in the somewhat near future. So as far as the construction phasing is concerned, the application has no bias currently towards how or when it would get built. There is a series of construction mitigation issues which were addressed in the department, in the DEIS, and then to your third point is the work of our studio is dedicated to sustainability. As you may know, our own personal office is the first LEED Platinum project of any kind in New York, first LEED Platinum skyscraper, first LEED Platinum in Empire State Building, and this applicant has committed to a LEED certification process, which also helps in the construction phase in erosion control and things like that. So we're encouraged that there's a sustainability component for this project also, besides what we hope to be the social sustainability issues. Was there a fourth? That was it? Thank you.
She's being very disciplined. Commissioner Efron.
Mine's really just a one-part question about the pedestrian access, particularly across West Street. Earlier this year, a 22-year-old was killed going across a crosswalk. He was a colleague of my husband, so it's something very personal. But if you could explain both the access to what might be a hotel and how you deal with pedestrian access, given that there was probably going to be a fair amount of unloading and taxi, maybe even taxi queuing, and where the proposed crosswalk would be.
Yes, thank you. Yeah, I'm sorry about your friend. This is one of the things that, besides the passion of the users of Pier 40, that have been remarkable supporters of the project. One of the things that come with that is the connection across West Street, which is a problem for our entire city. It's a highway. And what's happened now, well, you see the crosswalks are marked right now, and I'll do the existing ones first, is that and why this connection is here, is that crosswalk is on the north side of Houston. There is no crosswalk on the south side of Houston because there's a lot of traffic that's coming this way and making that bend. So this was considered the safest. The issue that we have here is the right-hand turn while pedestrians are in this crosswalk. And that's been a big pedestrian conflict. This is a really difficult thing when people are turning to head north on the highway and people are in the crosswalk right here, and the visibility is not great. The much better connection is at Clarkson. It's one of the reasons why we put the residential lobby here and the retail here, was to help reinforce that connection at Clarkson at grade. It's just much safer right here at this location because it's not directly at a busy intersection. There was some talk about conceptually about bridges and things like that and what would make the most sense. And so what we've done is gone to the state DOT and started the process of discussing getting a crosswalk at this point across the median right here, which would be away from the busy traffic intersection, connect to the through passage, and frankly would be very good for our project also, in that the two center residential buildings and the commercial building would also have a crosswalk at that location. So we started that process. It obviously can't get done within the ULURP, but she is here, could talk a little bit more about that too. That was something that came out in the multiple sessions with the community, is the desperate need for safe crossings of the highway, with the number of people both currently using, I think over 250,000 people a year using Pier 40, but also the anticipated increased use and demand for active play area on the waterfront.
Thank you.
So actually, my understanding, currently, there's no pedestrian crossing available between the south side of Houston Street and the south side of Spring Street?
Well, I believe it's all the way down at Spring Street.
Yes.
Is the next one.
So that's quite a long stretch
Yes.
today. And in order to do a crosswalk where you're suggesting would require what? Obviously, state DOT's approval, but a traffic light?
Yeah. May I introduce the person with expertise in this area? He was signed up as part of the first 5 speakers from AKRF. Would that be okay?
Yes.
Okay.
It's just a very quick question for him.
Hi, Commissioners. Chi Chan from AKRF, I'm the traffic engineer on the CIS.
So I'd just like to know, in order to actually create a pedestrian crossing south of Houston and somewhere north of Spring Street, assuming this location, what would be required in terms of change? It would require, obviously, traffic light. What else would be required? And obviously, state DOT approval.
Right.
What else?
Yeah, we took a conceptual look at it. This location would be about 800 feet from the Canal Street intersection and about 400 feet from West Houston. So there's enough room. It's not too close to any adjacent intersections. And you're right, there certainly needs to be a traffic light there. There will be some issues with utilities because we have to cut through the median. Also, on the park side, there's currently no landing for a crossing. So we'll have to work with Hudson River Park to see what kind of changes on the park side would need to be made. So in addition to state DOT, also with Hudson River Park.
Would the median, current median be wide enough to accommodate a crossing at that location?
Yeah, the median would be cut, but it could also function as a refuge area. as
It would
you
be wide
cross
enough
over.
to function as a
Yeah,
refuge
at that
area?
point, certainly, yeah.
Thank you. Commissioner Cantor, then Commissioner Knight.
On the river's side, seems to me that any truckloading to these stores would have to be coming along that service road, crossing Houston as well. And I assume the trucks have to be fully inside the building.
Well,
Could you speak to that, or is it too early?
Sure. We had extensive discussions with state DOT about how these driveways along West Street could work. We have done turning maneuvers and show them, what the turns would require. Obviously, they would have to get into the traffic lane. So the final discussion was that only smaller trucks are allowed to back into these docks, and they would back in with the help of certified flag persons. The larger vehicles would need to stay on curbside. There's already a curb lane there for parking. We'll need to work with DOT to figure out what the appropriate regulation would be to facilitate that.
By smaller trucks, you mean 33 footers?
Yeah, the single unit.
Which means when they're backing in, they close off the service road.
I'm sorry, on this
When
side,
they
right?
back- Yeah, when they're coming in and backing in,
Yeah.
they'd be closing the service road for the time that they're backing in.
No, I mean, this area over here
Yeah.
is about 20 foot wide or so, which encompass the first moving lane and the curb lane.
Okay.
So we go like that.
Commissioner Knight.
I wanted to go back to one of Commissioner De La Uz's questions about underwriting and whether or not each of these buildings are being underwritten separately and why the units aren't spread across, the affordable units aren't spread across the entire project.
I'm not an expert on financing, but I think we have considered this as a multi-building project. And so this project has 328,700 square feet of permanently affordable housing. That amounts to 25% of the floor area of the project and 30% of the units. And the way that it's configured is that there's 110,000 square foot separate senior building on the north side, and that was considered to be desirable programmatically because of the needs and the facilities that you'd want to have in there. And then there is a separate building that is a 50-50 building. So it's completely integrated that way. I mean, certainly the commission has seen come to it buildings with this kind of approach where in a multi-building project, there are some buildings which are entirely market rate, and there are some that are 50-50, and that's the approach here. And I suppose that that has to do to some degree with the overall financing and the ability of the project to make the contribution here. I mean, I don't think that represents, you know, a poor door. It's saying that there is, to the extent that there isn't a building that is integrated, it's fully integrated, it's 50-50. And it has shared services and joint entrances and no discrimination against the affordable. They all share the same amenities.
Any other questions for the applicant team? Thank you, Mr. Silliman. Thank you, Mr. Cook. We will now hear from the Hudson River Park Trust, and that is Madeline Wills and Dan Kurtz.
Thank you, Chairman. Good morning. I'm Madeline Wills, President and CEO of Hudson River Park Trust. On behalf of the Trust, I wish to extend our appreciation to City Planning for agreeing to host this joint hearing. Most especially, we'd like to extend our gratitude to City Planning for advancing the proposal to establish the Hudson River Park Special District and enable the transfer of floor area within the district pursuant to a proposed special permit. The Trust is a New York State public benefit corporation enabled by the Hudson River Park Act to design, build, and operate Hudson River Park, which includes Pier 40. Under the Act, Pier 40, the park's largest and only commercial pier south of 15th Street, is expected to generate significant income to help support the park, which receives no public funds for its operations. The Act also mandates that at least 50% of the equivalent of its footprint be public open space, and as you've heard, Pier 40 contains ball fields that are heavily used by the entire West Side community. Unfortunately, an independent engineering report stating that the majority of the 3,463 steel support piles are in poor structural condition and require urgent repair in order to keep the pier open. Because of the cost of pile repair, the Act's use restrictions and short lease term allowed for Pier 40, 2 previous attempts to develop the pier have failed. Pursuant to a 2013 amendment to the Act, the Trust is authorized to transfer by sale any unused development rights as may be available for transfer to properties located up to 1 block east of the boundaries of the park along the west side of Manhattan, if and to the extent designated and permitted under local zoning ordinances. The Act also requires that if any of these rights are transferred from Pier 40, revenues from such sale must be used in the first instance for the repair of the Pier 40 infrastructure. Prior to ULURP certification, an independent appraisal of 200,000 square feet of development rights to be transferred from Pier 40 to 550 Washington Street were valued at $74.7 million. The Trust and the developer negotiated a fee of $100 million to purchase the air rights. The Trust letter of May 3rd to the City Planning Commission identifies the infrastructure improvements needed at Pier 40 and confirms the sufficiency of funding to complete such identified improvements. The pile repairs will allow the pier to retain sufficient structural capacity to support public assembly and allow the pier to remain open for its current uses. In their recommendations, Community Board 2 and the Borough President request that the Trust be prohibited from selling any additional air rights within Community Board 2 if the current proposals are approved. The Trust publicly stated that its preference is to use the remaining FAR at Pier 40 as part of a future redevelopment of this pier, but that we will need to secure an amendment to the Act to allow both a longer lease term and additional uses similar to what occurred at Pier 57 before we can responsibly make this commitment. We have also pledged to work with elected officials and Community Board 2 on parameters for a redevelopment plan that uses the remaining development rights at Pier 40. After conclusion of the trust significant action period and evaluation of public comments by the trust staff and the board, and subject further to the successful conclusion of ULURP, the trust board will vote on the proposed purchase and sale agreement between the developer of 550 Washington Street and the trust. If the board approves, the agreement would then be executed, and upon closing, all of the $100 million proceeds paid over 4 years would be used at Pier 40 for these sorely needed infrastructure improvements. And thank you again on behalf of the trust.
Very efficiently done, Ms. Wills. Questions to Madeline Wills? Commissioner Efron.
Thank you so much. It was very efficiently done. I'll try to be
tried.
as efficient. Is there any risk to the payments not being made, given the 4-year payout and the 10-year term we're being asked to approve? And what happens if the project doesn't go forward? Do you retain the rights to the air rights?
I'll answer the last one first. We will retain the rights to the air rights if the transaction does not go through. We have right now a $5 million good faith deposit in escrow. We are currently using $1 million of that $5 million as we speak to start the design of the repairs for the piles. So should the ULURP not conclude, or should there be an adverse change to the project and the developer does not want to go forward, they can withdraw from ULURP, and we would have to return the remaining amount of that $5 million that we have not yet used. Should ULURP actually go forward and the project close, well, at the time that the board would approve the purchase and sale agreement, the developer has to put up another $35 million into escrow. At that time, should the project not close due to no issue with the project itself, then they would forego the $40 million that was in escrow at that point.
And sorry, if it goes, they get their financing, but circumstances change, and 2 years into the project before completion, it is abandoned, or?
If they close, they are, I believe if they, Mr. Kurtz may correct me on this, but if they close.
Okay, great.
Then we keep the $40 million, and if the project is abandoned, I assume that they would be in default at that point.
Great, thank you.
Commissioner Edie, then Commissioner Ortiz.
Hi, good afternoon. You referred to additional FAR that or development rights that Pier 40 has. How much additional air rights are there, or development rights?
It has approximately about 330,000 square feet in addition.
In addition to the 200? Okay,
Yes.
thank you.
Commissioner Ortiz.
Hi, good afternoon, I think. You mentioned the conditions of the pier and the pilings, and that's certainly a concern. So what, did the study, I imagine, laid out a time frame upon which, this needed to happen? I mean,
Yes.
what kind of urgency are we talking about here?
The study was completed, the actual diving was completed at the end or the beginning of 2015, and it was reported at the time that we needed to start immediately.
Okay. So the contribution is $100 million. What were the air rights appraised at for the public record?
$74.7 million.
Okay, so this is a $25 million over on
Yes.
what the air rights, which, okay. And, absent this contribution, what other mechanisms are there at this time for raising the money associated with pier improvements so that we can prevent the failure of this amenity, this community amenity?
We don't have a Plan B right now. As I'm sure you know, there's been a long and painful history on Pier 40 in terms of making sure that it has, it survives. It's a very It's a building and a pier that's been in disrepair and has been neglected for decades before the Hudson River Park Trust ever took it over. So we don't actually have a plan on how to
I
repair it.
understand there have been many attempts to answer that question.
Yes.
More that this project, I mean, it suggests the importance
We are
of this project.
grateful for the state legislature that they gave us this opportunity.
Thank you.
Any other questions for Ms. Wills? Thank you.
Thank you.
And the next speaker from the trust is the aforementioned Dan Kurtz.
Chairman Weisbrot, Commissioners. I think Ms. Wills covered the topics quite thoroughly. I'll just provide some further description in response to the Commissioner's question regarding the purchase price. The way the transaction is structured is that upon closing, there will be a chairman's certification indicating that the payment procedure and the payment documents are fully in force with regard to the full payment. The way the transaction is currently contemplated, the developer will pay at closing $40 million, which includes amounts that may have been drawn down prior to closing for, as Ms. Wills described, for further engineering studies, for the preparation of construction documents such that the pier work can start promptly as soon as closing occurs. The balance of the funds are secured by a promissory note. Promissory note is, as the Chairman noted, payable in 3 $20 million installments. And to provide the necessary security for the public entity, for the public authority, which is the trust, the balance of the purchase price of $60 million secured by the promissory note is also secured 100% by a letter of credit issued by an investment-grade financial institution. So there'll be no question but that the funds will be available for payment to the trust for undertaking the vital infrastructure repairs when they are due. So there will be no risk to the trust of complete payment, regardless of what happens to the private development. If it's delayed, if there's a failure on the part of the developer for reasons that we currently can't contemplate, the funds that are available to secure the purchase price will be in place independent, and the trust can rely 100% on that, so that the funds will be available for the infrastructure repair.
You just set forth, what are the conditions and timing of closing? And from your perspective, assuming this action in whatever form is approved by the commission and ultimately by the city council and by the trust board, what are the conditions upon which have to take place and the timing for closing to occur?
There's some technical things which have to be accomplished, which I'm not going to facilitate to discuss in terms of providing certain legal documents, but in terms of the timing, within, and I'm sorry, I don't recall what the exact number is, I think it's 30, it could be 60 days after the Hudson River Park Board approves the transaction, the purchase and sale agreement has to be entered into, at which point the developer does put down $40 million as security in advance of the closing. And then the closing, the date of the closing, it has to occur within 7 months of the board approval. 4 months has been allocated, this being New York City, for the possibility of an Article 78, and then the developer has to close within 90 days with time of the essence with regard to the closing. So at the conclusion of the Article 78 period, the 4-month period, the developer needs a certain amount of time to finalize his financing so that the funds will be available. And then upon issuance of the chairman's certification, that the agreements are fully enforceable and there, then the closing would occur.
Thank you. Mr. Commissioner Dweck.
Question. You had mentioned that the payments are spread out over 4 years in total?
3 years.
Three
3 years
plus
following
the-
closing, yes.
Right. So are the repairs to the pier commensurate with that timeline?
Yes, they are. It's as President Wills indicated, there's There are 3,500 piles to repair. Given that there are constraints in terms of the timing in which those repairs can occur in terms of environmental and also more practical considerations with regard to the temperature, a lot of this work involves pumping concrete. It can only occur best occurs during certain months. So it will take a multi-year period in order to accomplish the piles.
So the payment are not delaying the actual work?
It
The
will not
scheduled
delay.
payments will not?
It will not delay, and in anticipation of that, the engineer has laid out a priority of work to be accomplished so that the worst portions of the piles can be addressed first.
Thank you.
Commissioner Edie.
Just to make sure I understand correctly, so the vesting of the development rights to the developer occurs at closing of all the development rights, that 200,000 square feet?
Yes, that's correct.
Okay, thanks.
Any other questions for Mr. Kurtz? Thank you, Mr.
Thank you very much.
Kurtz. The next speaker, before we go into those in opposition, is the distinguished Borough President of the Borough of Manhattan, Gail Brewer. Welcome,
Thank you very much,
Madam
Mr.
President.
Chair. Thank you. So I am Gail Brewer, and I am the Manhattan Borough President, and I think...
And you are distinguished, all
I
of
am.
those things.
You are also distinguished because we're old.
Fair enough.
But thank you for the opportunity to testify today on the redevelopment of St. John's Terminal Site and, of course, the payment for development rights to the Hudson River Park Trust for Pier 40. We just had a good discussion of that. So I would like to thank you and your staff, Mr. Chair, for your hard work in crafting a text amendment that creates a special permit to facilitate transfers of development rights from the park to a receiving site. The use of this special permit must go through ULURP, as you know, and I support the text amendment, but think a cap should be added to make sure, as Madeline Wills indicated, we would say this, to make sure no additional rights are transferred from Pier 40 into Community District 2. This brings me to the matter that I will spend the bulk, pun intended, of my remarks on. The proposal before the City Planning Commission today is the biggest single development in the history of the neighborhood in the last 100 years. The development isn't just large in terms of the parcel of land involved, bringing more than 1,500 units to 2 blocks. The proposed development's physical height and residential density will create a massive building that hooks over the neighborhood. The project will have adverse impacts on transportation and open space and will create issues, as we know, during construction. If we're going to ask a neighborhood to accept this kind of density and the impacts that go along with it, we have to make sure we have done everything possible to shape the project in a manner that most benefits the neighborhood, addresses its needs, and mitigates those impacts. I do believe this project falls short of that standard. I think we can do a better job in stitching this development into the surrounding neighborhood, ameliorating the impacts on parking and open space, and improving the location and design of the proposed affordable housing. So how can this project be improved? 1, eliminate most of the proposed parking, and you heard a discussion, I could hear it right back here. Throw out the big box store, not the grocery store, but others should be neighborhood-based completely, and you know how I feel about chain stores. Create a great open space and pedestrian realm plan, and 4, increase the amount of affordable housing. So let's talk about the parking. I understand the need for some flexibility for such a large development, like the parking garage on the north site, but I cannot support the special permits for additional parking on the south and center sites. These permits would put so many parking spaces in the project that would, as you heard earlier, use up the permitted parking ratio for the entire neighborhood and would cause huge impacts. And the below-grade space can be better used. For example, in addition to active recreation indoor space, elimination of the parking below grade creates opportunities for cultural uses such as rehearsal space, small theaters and galleries desperately needed in Manhattan. These types of uses will help draw people to the site and create additional foot traffic. Active indoor recreation space and cultural uses are far more compatible with the park and the general purposes of the special Hudson River Park District. So these 2 additional special permits, in my opinion, for parking should not be granted. This proposed development also lacks a cohesive pedestrian rail plan, and yes, That includes retail and how people move in around the site. There is a lack of small retail spaces along West Houston and Clarkson Streets, and the additional through-block connector is designed as a gigantic driveway focused on vehicles rather than people. This is why a big box store, except for the grocery store, is a no-go. It will cause significant traffic problems, and it's not the type of neighborhood retail that either the community board or I want. We don't need destination retail here. We need neighborhood retail, an affordable supermarket, and small business corridors with multiple smaller stores along West Houston, Clarkson, and Washington Streets. We need eyes and doors on the street and lighting activity. If this development is to look outward, which it should, it must provide retail opportunities that serve its residents and those who live in the surrounding neighborhood, which it intends to be a part of, not an island unto itself. The environmental review is clear that this proposal will substantially increase demand on open space. Yet the proposal does little to provide new space to the proposed residents or the neighborhood to offset its density. These impacts can be addressed by creating more at-grade, usable open space in addition to the courtyard and below-grade active recreation space, which would come from eliminating the additional parking garages. While creating an accessible courtyard is a first step, the through-site driveway must be activated with lighting, additional planting, and seating to serve pedestrians first, not cars. This will help offset the open space impact and create an additional pathway to the park. The above-grade publicly accessible areas over West Houston Street, while beautifully designed, will never have the same utility as at-grade space. Keeping 3 rail beds will darken West Houston Street. The 2 at the farthest edge of the block should be removed. And you know me, I hate to remove anything old, except you and me. And a plan developed for lighting the underside of the remaining one. In addition, there has to be a retail plan for smaller and active frontages with street-level entrances to invite the public to use this street. This project does provide sorely needed affordable housing. However, given its impacts and the need for the community, the housing plan can be improved. First, almost all of the affordable housing units in the project could end up being contained in buildings on the east side of the sites, furthest from the Hudson River and the park, and closest to the UPS building and manufacturing. Second, I am concerned that the size of the senior units will make them unappealing to seniors, especially to those not living alone. As proposed, 75% of these units will be studio apartments. Even seniors living alone but downsizing from their previous homes may find living in a studio difficult, and I know many projects where there are studios, but if you're starting from scratch, it's best to do it right. But those in couples who have help in the home may find this living situation difficult and untenable. The ratio should be flipped. Third, I believe that the value of the air rights should not have been discounted for the provision of affordable housing. Affordable housing is the cost of doing business in this city. We should expect it without offering discounts. Given the size of the project, it's big. The extent of the waivers and the funding to the pier, I am convinced that we could have gotten additional affordable housing, and we should look at that. Last, a significant part of the affordability package should be how all residents access amenities, and we heard that all will be able to access amenities, but there's a but. All amenities, including exercise and recreation space beyond that which is required under zoning, should be accessed for free or capped at a total cost not to exceed 20 or 30% for the affordable tenants, because you can have accessible amenities, but you can't afford them. So I want to thank you very much, because I know a lot of time has gone into this from the trust and from the commission. I mean, of course, if I had my way, the city and the state would split the cost of the piers, because God knows we need Pier 40. But I know the act gives the opportunity for a project. But in the best of all worlds, the government should be paying for these piers. Thank you very much.
Thank you, Madam Borough President. Questions to the Borough President?
Thank you very much.
Thank you very much. We will now go to the first 5 speakers in opposition, and I will call all their names, and then we'll go to 5 speakers in support. The first 5 in opposition: Melvin Stevens, Andrew Berman, Sam Moskowitz, Matthew Morowitz, and Linnell Stevens. So let's start with Melvin Stevens.
I have an exhibit, I'd like this to be put into the record. It's my one board. If it stays there. All right, Commissioner Weisbrod, Commissioners. My name is Melvin Stevens. I've been a Greenwich Village resident for 50 years. New Yorkers have, over time, recognized the intrinsic value of the shoreline, of their shoreline. And this is nowhere more evident than in New Yorkers' love for their river, the Hudson, a natural resource and public waterway. But there is an irony. As valuable as the Hudson River is an environmental and ecological treasure, it also has become fair game for rapacious developers, overreaching politicians, and for those who are in power and those who wish to stay in power. And it is because of that irony that I come before you with hat in hand and implore you to deny the Pier 40 air rights transfer to the ill-conceived monster known as 550 Washington Street development. The Hudson River is a public waterway, and under common law is meant to be shared by all New Yorkers and not just the affluent few. It also should be noted that it is a navigable waterway allowing no development in, on, or over the river. I have two postscripts. The first one, as part of the transfer deal, Pier 40 will be repiled. The thousands of piles necessary to stabilize Pier 40 will stab into the riverbed, destroying the aquatic habitat. By the way, the same scenario will be repeated by Diller's Island, and that's going to require 841 pilings. And I think earlier somebody from HRPT said that it would take somewhat like 3,000 piles to stab into the riverbed, destroying a viable fish habitat. I would also like to post another postscript, a question to Andrew Berman, Director of the Greenwich Village Society for Historic Preservation. Do you know that the 550 Washington Street development can be stopped by denying the project at Pier 40, by denying the project a Pier 40 air rights transfer? And Commissioner Weisbrod, were you responsible for any air right promulgation or laws earlier on?
We get to ask you the questions. You don't get to ask us the
I don't
questions.
get it. Oh, come on. All right, that's your answer. That's your answer. Thank you.
Thank you, Mr. Stevens. So the next speaker is the aforementioned Andrew Berman.
Good afternoon. My name is Andrew Berman. I'm the Executive Director of the Greenwich Village Society for Historic Preservation, the largest membership organization in Greenwich Village, the East Village, and NoHo. Our organization has deep and varied objections to the proposed rezoning, approvals, and the creation of the Hudson River Park Special District. And thousands of our members and supporters have written the Commission and other city and state officials to that effect. The proposed development is ludicrously oversized, 70% larger than the already generous zoning for the site allows, with the added benefit to the developer of granting exponentially more profitable residential and hotel uses where they are currently prohibited. The proposed development will be overwhelming to the surrounding area with few, if any, public amenities on a site ill-suited for this scale of development. Allowing the transfer of air rights from the Hudson River Park to this or any other site is fundamentally flawed policy and ignores other, better options for funding the park, which we and dozens of other community groups have proposed. The proposed development in its current form would generate huge amounts of traffic with the 200,000 to 300,000 square feet of big box and destination retail, which would draw an enormous number of vehicles to this already traffic clogged area from around the metropolitan area. And the proposed development and rezoning would increase development pressure upon the nearby historic unlandmarked portion of the South Village, while the creation of the special Hudson River Park District has the potential to unleash 1.5 million square feet of air rights upon West Side communities. Should the city choose to move ahead with this ill-considered and inappropriate plan, the following changes should and must be made in order to provide adequate protections to adjacent neighborhoods. First, the city must move ahead with the long overdue landmark designation of the final phase of the proposed South Village Historic District. We've been calling for designation of these 11 blocks and 175 buildings for over 10 years. They've been listed on the state and national registers of historic places, and the other 2/3 of this proposed district were designated in 2010 and 2013. These low-rise historic residential blocks south of Houston Street face increasing development pressure and loss of historic fabric, and landmark designation concurrently with or before any rezoning is essential to protect them. Secondly, any Hudson River Park Special District must include a clear, strict, and concrete prohibition on any future air rights transfers from anywhere in the Hudson River Park to anywhere within Community Board Number 2. Such language should make absolutely clear that it is the intention of all parties that no such transfers from the park should ever take place within Board 2 again, whether through this mechanism or any other. And finally, all big box stores and destination retail must be eliminated from the proposed development, with all retail uses limited in size and scope to those serving local retail needs. Only a supermarket should be allowed to exceed strict limits upon the size of stores. Thank you very much.
Thank you, Mr. Berman. Questions for Mr. Berman? Commissioner Ortiz.
Hi, could you define for us what you mean by big box and destination in terms of, how much square footage a big box in your mind takes up, and what kinds of uses might be categorized as either big box or destination?
Sure. Well, in terms of the proposal before you, it certainly seems as though, as was discussed earlier, that things of a size of 5 or 10,000 or greater square feet is clearly not locally oriented and is big box, with the exception of something like a supermarket. Generally speaking, I think that locally oriented retail is in the certainly at the very least in the 5 digits in terms of the number of square feet. 4,000, 5,000 at most would be the upper end. And I actually think that the most important thing is what the kinds of uses are, at least as important as the size of them. You could have a very large footprint space, again, such as a supermarket that is really geared towards the local community. You could also have a series of relatively small stores that have a mall-like orientation and that are bringing people in from all over the metropolitan areas as opposed to serving the local community. So we think a relatively small size but also a local orientation is very important in terms of what the stores should be.
I thought it was interesting that the architect mentioned the spaces could be further subdivided into smaller spaces. Does that remedy some of your concern?
Well, I think the issue is not what could happen, but what we require happens. I think left to their own devices, they'll do whatever they can make the maximum profit off of. So it's very important that we not simply leave it to them to say, well, we could subdivide it to smaller spaces, or we hope to bring in a supermarket, or we hope to have local service. I think it's got to be a strict and clear requirement of any of the approvals that are granted.
Thank you.
Just to follow up on that, so your concern would not be with the overall amount of retail space if it was strictly subdivided so that it precluded big box. Is that a fair statement?
Yeah, we're not asking for a specific limit in terms of the total amount. What we're asking for is that the orientation and the size be towards local retail and the local community.
Thank you. Is any other questions for Mr. Berman? Thank you.
Thanks.
Next speaker is Sam Moskowitz.
Hello. My name's Sam Moskowitz. I'm with the Greenwich Village Society for Historic Preservation. Allowing air rights transfers from the Hudson River Park is deeply problematic and troubling. Amazingly, 3 years after the New York State Legislature changed the Hudson River Park Act at the end of the legislative session with no public notice to allow such transfers, neither they, the trust, nor the city have yet cataloged how many air rights are in the park's commercial piers, which could be transferred inland. Equally amazing, enabling such air rights transfers was never necessary to fund the completion of the park, as has been alleged, nor is it the best way to do so. the Greenwich Village Society for Historic Preservation and more than 24 neighborhood groups urge city and state officials to instead consider placing a dedicated tax upon new developments adjacent to the park as a means of generating income for its completion and maintenance, as has been done in Battery Park, Hudson Yards, Hudson Square, among other places. Such a system could generate more income and would not contribute to overdevelopment of these adjacent areas. Why was such a system never pursued or considered by the city, state, or trust? Is it that it would not create the same enormous windfall for developers as the air rights system, nor would it leverage the upzoning of waterfront areas that many have sought for years? Either way, we think that creating a system to allow air rights transfers from the park, even just its commercial peers, is bad policy and a huge burden upon these communities. The potential overdevelopment of neighboring communities resulting from the 1.6 million square feet of air rights that the trust has estimated the park could provide is staggering. All parties involved with the decision-making in this case, however, seem committed to enabling at least some air rights transfers to take place. If any air rights are allowed to be transferred from Pier 40 to the St. John site, as is proposed here, and a special Hudson River Park district is created, it must include a strict prohibition on any future air rights transfers anywhere else in Community Board 2. The trust and others have falsely claimed that there are no other sites in CB2 where air rights could be transferred in the future. This is patently and demonstrably false. Within the one-block inland zone to which air rights can be transferred, there are several sites without landmark protections and with no zoning heights limits where air rights could easily be transferred, including the blocks both north and south of Little West 12th Street, as well as between Clarkson and Leroy Street. If current contextual zone limits were changed, which this mayor and the City Planning Commission have shown themselves all too willing to do, and which could easily be a part of any air rights transfer rezoning, then there are literally a dozen sites between Leroy and 14th Street where such air rights could go, significantly increasing allowable development in this area. Allowing the transfer of air rights from the park to inland areas is wrong, period, but unfortunately the state legislature has already made that possible. If you do allow it, there must be concrete assurances that this is the one and only time it is allowed in Community Board 2, by strictly and explicitly prohibiting it in the future.
Thank you, Mr. Moskowitz. I have a sort of a conceptual question for you. You know, when the Hudson River Park was first established many decades ago, Pier 40 was always designated as a commercial site that would generate revenue to support the rest of the park, as is true in several other major parks. And it's a model that's been used elsewhere. And here, the notion, as I understand it, is to, in part, to enable Pier 40 to be more of a public area and less of a revenue generator, and by transferring air rights away from the park and off the park, doesn't that actually advance the ultimate purpose of the park?
Would you mind if Andrew Berman answers that question?
Yes, you're here.
Okay. Well, I'd like to say that I don't know the intentions of the development when that law was passed 100%, but I'd like to think that the fundraising came from the parking that was available there, or the space rental to other groups to come in and use the park. I don't think there was ever the intention that many years ago that there would even be air rights transferred available to be transferred future 5, 10 years from that point.
Well, I think if you look at the history of the park, you will see that this was intended originally to be a significant revenue generator, and one of the accomplishments of transferring air rights, and I appreciate what you're saying, but one of the consequences or accomplishments of transferring air rights is to allow a greater recreational use of the park and of Pier 40, and reduce the need for Pier 40 to be a revenue generator.
I don't think our position is no air rights transfers, because we understand that is going to happen probably at some point, but to limit those so they're really only limited to this current development and not really allow the overdevelopment of the west side from Leroy to 14th Street.
Any other questions for Mr. Moskowitz? Thank you.
Thank you.
Next speaker is Matthew Morowitz.
Hi.
Hi.
Hi, I'm Matthew Marwitz. I'm with the Greenwich Village Society for Historic Preservation. The 11 blocks and 175 buildings between West Houston and Watts Street, 6th Avenue and West Broadway, which form the final and not yet landmarked phase of the proposed South Village Historic District, are uniquely rich in New York and American history. They are also under huge amounts of development pressure, with historic buildings coming down, out-of-scale new developments going up every day. This pressure will only increase if this rezoning is passed without the long overdue landmark protections this area needs. It's not just GVSHP which thinks this historic area merits preservation. In 2006, we proposed this area for designation along with 25 other blocks of the South Village, which have since been landmarked. Since then, these blocks have been listed on the state and national registers of historic places. They were deemed one of the 7 most historically significant and endangered sites in New York State by the Preservation League of New York State in 2012. Every local elected official who has represented the area since the proposal was first made has supported designation, including both current city council members and the borough president. The community board supports it. Every local block association and civic group supports it. And literally thousands of area residents and other New Yorkers have written to the city urging designation. The only relevant entities to not yet support designation is the Landmarks Preservation Commission and the mayor. Support for designation is strong with good reason. Walking down these streets literally transports you back in time to turn of the last century New York, when this neighborhood was awash with immigrants and just starting to become home to a new generation of New Yorkers who were attracted to the area's unconventional and iconoclastic streets and culture. It's home to America's oldest extant Italian-American church, a rich array of model tenement houses, some of Lower Manhattan's oldest surviving houses, and remarkably intact tenements built by and for immigrants in every conceivable style, shape, and configuration. If only the last few years, that historic fabric has begun to fray, however, with an almost uniformly 2 to 6 story landscape being replaced by 150-foot tall towers. Current zoning would actually allow 300-foot tall towers on some sites, and the proposed St. John's rezoning nearby will only increase the likelihood of this happening sooner and more frequently. That is why, if the proposed zoning and other approvals are to be granted, it should only be done so if this final leg of the proposed South Village Historic District is landmarked in its entirety. This must take place concurrently with or before the rezoning take effect. We know that timing for this is very tight, but we have been calling for this for over a year, and the community board and our council member have been raising this for some time as well. We have no doubt that if the city wanted to do this, it would be done. Thank you.
Thank you, Mr. Marwitz. Questions for Mr. Marwitz? Thank you. Next speaker is Linnell Stevens.
Good afternoon.
Good afternoon.
My name is Linnell Stevens, and I'm with the Greenwich Village Society for Historic Preservation. The proposed development on the St. John's site would include 200,000 to 300,000 square feet of big box stores and destination retail. That's about the size of the entire 6-block Rockefeller Center retail concourse, or more than 4 times the retail space at Chelsea Market. Think about the foot traffic those retail centers generate. But Rockefeller Center is located literally on top of several major subway lines, and Chelsea Market is but 1 block from 3 major subway lines and just 1 block further from 3 more. The St. John's terminal site, however, which this developer proposes to turn into big box and destination retail hub, is 3 long avenue blocks from a single local subway line. It is, however, surrounded by streets and tunnels which eventually lead to every corner of the New York metropolitan area. And while these are some of the most congested and overburdened streets in the entire city, it is no doubt by this means, by car, that shoppers will come to this new shopping hub if this developer is granted the approvals being sought. This would be devastating for the surrounding areas, the West Village, the South Village, Hudson Square, and West Soho. The West and South Village are residential neighborhoods. The city has been seeking to increase the residential population of Hudson Square and West Soho. These areas already see traffic backups emanating from the Holland Tunnel that stretch for blocks and last for hours. Adding into the mix thousands of shoppers trying to reach and return from the area by car would be an unmitigated disaster. That is why we are urging that if any proposals are granted for this site, they must prohibit any big box store developments and must eliminate all destination retail. Retail should be restricted in size and types to stores that will serve the local community. Larger individual stores should only be allowed for a supermarket. This increasing residential area has a more than large enough permanent population to make the retail spaces here viable by orienting them towards the surrounding community. A destination retail or big box component will only add to the area's already vexing traffic problems and to the overwhelming and negative impact which this proposed development will have on the surrounding area. Thank you.
Thank you, Ms. Stevens. Questions for Ms. Stevens? Thank you.
Thank you.
We will now go to 5 speakers in favor, or largely in favor. And those 5 are Anita Brandt from Community Board 2, Rich Cacapolo from Community Board 2, Shirley Secunda from Community Board 2, Terry Cude from Community Board 2, and Eric Botcher from Council Member Corey Johnson's office. Welcome, Ms. Bryan.
Good
Brandt.
afternoon. Thank you for the opportunity to speak on behalf of Community Board 2 Manhattan. My name is Anita Brandt, and I'm the chair of CB2 Land Use Committee. CB2 voted to recommend approval of the rezoning of this site with the caveat that improvements be made so the project can be better reintegrated into the neighborhood fabric. My fellow board members will discuss open space, traffic, affordable housing, and parking, and I will touch on land use and site planning. The following 7 items highlight our recommendations. Number 1, reopen King Street and possibly Charlton, and include street-level activities and attractions. These streets could be reintegrated in the future, will reduce the length of the blocks, provide more options to pedestrians, and reference the scale of local streets. Number 2, set back the building along Washington Street to improve pedestrian and vehicular traffic and provide a buffer both from new and existing uses. Number 3, open Houston Street to the sky. Leave only 1 pedestrian bridge. Number 4, provide open public space, pedestrian access in the area between the east and west buildings in the center site. Number 5, shift the height and density from the north site to the center site. Number 6, except for a grocery store, limit retail stores to 10,000 square feet and restaurants and cafes to 5,000 square feet, including below-grade areas. Number 7, reduce parking and use underground areas for commercial uses with community benefits, such as recreation and rehearsal spaces. In closing, although this project includes 160,000 square feet of retail, the distribution fails to contribute to a lively urban streetscape. Houston Street remains largely covered by bridges to create a second-level open space that is unlikely to attract public use. In fact, they're created at the expense of opening the street below to light and air. As presented, the design represents a monolithic, forbidding, and inward-facing structure with 800-foot-long street walls. This street wall is broken up by only 2 unwelcoming and remote streets, the Houston Street Tunnel, and a private driveway. Rezoning is justified when new uses and increased density contribute to the success of the surrounding area. If the challenges detailed in our resolution cannot be met, the rezoning is not justified. We ask that the Commission carefully consider our concerns and recommendations as documented in our resolution.
Thank you. Thank you. Any questions? Ms. Ortiz?
Hi. One of the things that has come up is the placement of the retail and sort of the mention of the desire to have it perhaps face Washington and less Houston, perhaps. And thinking about that and the degree to which Houston is the connection that the neighborhood has to this amenity, Pier 40. and it's, you know, widely traversed. There must be more pedestrian traffic on that. Doesn't it make sense to activate that section with retail?
Absolutely, but I don't think, if you're familiar with it now, it's a very aggressive, loud, noisy, and unpleasant
It
place.
feels like a tunnel.
Yes, and even though it's kind of definitely a cool idea with the sort of the High Line motif, it's not really a High Line because it's not going anywhere, but also it really closes down the street. And I think to add sky and light would help any kind of retail, any kind of activity on Houston Street, and make it a more attractive pedestrian walkway, as well as Washington Street, which is kind of brutal. It's back of house now. There's no there. No small shops, no streets, no reason to go down there, and the distances are so far. They're not broken up into neighborhood-like streets.
Okay, thank you.
Any other questions for Ms. Brandt? Commissioner Delos?
Ms. Brandt, the community board had a very thoughtful and lengthy response, and obviously you highlighted a number of them now. Could you maybe talk through how many of the concerns that you've raised, either here or in the letter, have previously been brought to the development team, and what responses there have been so far?
We have had good conversations. I have to say, it's not for lack of talent and so on, but I think the changes were ultimately nominal, if I have to get down to it. I think we were heard, but I don't think that there was really no change. The floor plan is pretty much the way it was when we started the process, even though they were willing to listen, but I don't think it's reflected in the project.
So you're saying that the concerns that are reflected in the recommendation have been consistent from the time that the community board has met?
What was the word?
Have they been consistent? Have the concerns been consistent?
Well, I would say that it was not right off the bat, because these are complicated issues and we're volunteers, and as we got into it, it really came apparent how the community felt, and it's so easy to fall in love with something, but it may not be the best thing for this site, for this purpose. And so we started to analyze it in a much more detailed way. So I think from the very beginning, no, we just weren't there. But certainly the last, couple of months. I mean, we've had many, 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 many meetings, presentations, conversations, and but the bottom line is I don't see it reflected. I think there's a willingness, but there's nothing concrete to point to. Although I was trying to listen outside, and there was no image, so I wanted to make sure nothing really had changed, but.
Any other questions for Ms. Brandt? Thank you.
Here.
The next speaker is Rich Cacapola.
Good afternoon, Mr. Chairman. Good afternoon, Commissioners. My name is Rich Cacapola. I'm the chair of the Community Board 2 Manhattan Parks and Waterfront Committee. I'm here to speak on the topic of and concerns about open space, that is the effects on open space from this proposed project. As noted in Community Board 2's resolution, our committee, our board, supports this project, more specifically the transfer of 200,000 square feet of air rights from the park to 550 Washington Street site, because doing so will provide much-needed funds for the repairs of our most crucial open space, open recreation space, that is Pier 40. In fact, we believe this will assure its continued operation, which is great. However, we have some concerns, and as mentioned by my colleagues, one of them is that we're concerned about the pressure on the neighborhood from additional development, and only support this transfer if protections can be implemented via the creation of the South Village Historic District and permanent restrictions of any additional development right transfer from Hudson River Park to sites in Community Board 2 beyond the 200,000 proposed here. Our most crucial or most substantial concern about the project plan is that it fails to mitigate the significant, as admitted in the EIS, adverse impact on active open recreation space in our district. And we understand that this is challenging, that it's very hard to find suitable outdoor space within the study area. So we propose and request the following be investigated. To mitigate the lack of outdoor space, we suggest that qualified and adequate indoor space within the study area, by that I mean within the project space, should be contributed for new gyms, new swimming pools, recreational uses, access to which would not be for commercial purposes. We're not talking about private health clubs, but for community use at no or very nominal cost for users. And we urge the city to support open space priorities that may be outside the study area, but are within the district, including the DEP sites, what are commonly referred to as the water tunnel sites, and the Elizabeth Street Garden. Now, finding active recreation space is a challenge, as we've said. That makes the optimal design of the passive space in the project even more crucial. And to that end, we request elimination of the design idea for passive open space on the second floor, on the old railroad tracks, above Houston Street. Instead, we would like to see the designation of a larger public open space to be created in the area between the buildings at street level, at grade, within the center site of the project. A courtyard has been referred to here, and that includes gardens and trees with seating and pedestrian access to and through the site from Houston Street. Further, as you'll soon hear from my colleague on our Traffic and Transportation Committee, they're going to request investigation concurrent with the Euler process of means to mitigate traffic congestion. My committee also requests that such studies include the provisioning of safe access from the project to Hudson River Park, as has been discussed earlier today. And finally, we would, along with the emergency repairs of the Pier 40 pilings, we would like to see consideration of funding for the maintenance of Pier 40 on an ongoing basis, perhaps through condominium fees, as has been done at the Reade development in our district for the St. Vincent's Park.
Very well timed.
Thank you. Yeah. Say I
You're getting to
practiced,
be
but-
good at this. Any questions to Mr. Cacapolo? Commissioner Ortiz.
Hi. You know, I noted the point that you made, which was that, you know, the transfer of air rights allows for the continued use of Pier 40 as, you know, an amazing recreation space. How many acres is Pier 40?
15, 1-5.
15
I
acres,
believe
okay.
it's 15, yes.
And, you know, it's clearly a public amenity. But how do you, you know, and then there's a request for additional recreational amenities within this project. And it seems that, you know, we have an abundance of recreational activities within HRP that, within Hudson River Park, that this community can avail themselves of. What's the rationale for wanting more on-site when we have a fantastic park across the street?
Well, even considering Hudson River Park, our district is, I think, the second lowest in terms of open space in the city per capita. It's well below the guidelines. And now we're adding in a great deal more residents. And as the EIS admitted, and it clearly pointed out, didn't try to hide, that's going to reduce the amount of open space per resident in the district already.
Well, I asked this question because, you know, during a review session, it came up for me, and I asked whether the residential study area included HRP, and the only portion of the study area, or only the HRP portion that was in the study area was included in that analysis. So, you know, they didn't take into account the fact that you have the entirety of the park really across the street from the district. So, you know, the analysis and the outcomes of that analysis don't necessarily suggest that you're underparked.
Is that a question or?
No, it's just a common observation. You know, it's a balance, right, that we're trying to achieve.
Any other questions for Mr. Cacapolo? Thank you.
Thank you.
So the next speaker is a distinguished council member himself, Corey Johnson.
Good to see you.
Welcome, Councilman.
Thank you. Good to see you, Chair. I want to thank the City Planning Commission and the Hudson River Park Trust for this opportunity to submit testimony regarding the redevelopment of the St. John's Terminal Building at 550 Washington Street, the creation of the Hudson River Park Special District, and the proposed transfer of air rights from Pier 40 in the Hudson River Park. Excuse me. With the participation of the Department of City Planning and this commission, community boards, the borough president, the city council, and the mayor's office, the Uniform Land Use Review Procedure process is designed to ensure that land use applications receive full public review and ultimately result in projects that produce true public value. The city council plays an extremely important role in this process, as you know, and this is a responsibility that I take very seriously. The challenges facing all parties in this ULURP include producing an application that funds the urgently needed repairs to Pier 40, provides an ample number of desperately needed affordable apartments for middle and working class New Yorkers in Greenwich Village, and mitigates the project impact and achieves a design that weaves this development into the surrounding neighborhood. My colleagues in government and I have laid out many concerns that we've had about this application. Our concerns include, but are not limited to, the layout of the buildings, the amount of parking proposed on site, the proposed size and location of the affordable units, the proposed layout of open space, and the proposed inclusion of big block retail as part of this plan. During the City Council's review of this application, I look forward to hearing solutions from the applicant that address these concerns. I will not approve a project that does not adequately serve the needs of the community that I was elected to represent. It is also critical at this juncture to identify measures that the city and the Hudson River Park Trust must undertake to make this a viable project for the community. This is the focus of my testimony before you today. The City of New York, in my estimation, and in the other elected officials' estimation that represent the area, must make a capital contribution to the preservation of Pier 40. While the 550 Washington Street proposal would allow for the transfer of air rights that would give $100 million to Pier 40, significant underfunded capital needs would persist even following the infusion from the private transaction contemplated by this proposed project. According to the Hudson River Park Trust, in addition to the piling repairs, necessary repairs include electrical work, artificial field replacement, and fire sprinkler repair. The trust estimates the immediate term needs through year 4 to be $21.5 million on top of what it's going to cost for piling work. The existence of the Hudson River Park alone has increased neighboring property values and thus earned the city added tax revenue. I would also note that New York City recently invested hundreds of millions of dollars in other parks around the city, and rightly so. These investments include a $50 million for a proposed indoor pool on Staten Island, $307 million for Governor's Island over the past many years. Investing in these vital community resources is a noble cause, and I mention these examples only to point out that Hudson River Park, which hosts 17 million people annually, is equally worthy of city investment. The City of New York must extend the South Village Historic District. Residents of the South Village honor the historical and cultural significance that has made their neighborhood a world-class destination. They also reasonably fear that their quality of life and the character of their neighborhood will suffer from further escalating development in the coming years. When the City Planning Commission and the City Council in 2013 handled the Hudson Square rezoning, Phase 2 of the South Village was landmarked at that point, and I hope that Phase 3 of the South Village will be landmarked as part of this process. If we're to approve the 550 Washington application, the city must also extend landmark protections to the historic blocks south of Houston Street. A southward extension of the South Village Historic District will give this historic neighborhood the protections it deserves, ensuring that any new structures are contextual, regulated, and reasonably sized. The South Village is a neighborhood with a rich history and well-deserving of this status, and such a designation will ensure that it is protected for future generations. And I am asking that this designation happen simultaneously of when the council is voting on the ULURP application. The City of New York must also conduct a comprehensive transportation study concurrently with this ULURP application to provide recommendations for improving traffic and pedestrian safety conditions in the area surrounding 550 Washington. Currently, traffic and pedestrian safety conditions in the area are severely lacking, mainly because of the nearby entrance to the Holland Tunnel, Varick Street, Canal Street, West Street, and Spring Street are all in a state of constant traffic gridlock. Go there basically any time of day, 7 days a week. This creates adverse conditions for pedestrians, local residents, businesses, emergency response vehicles, and countless motorists every day. The creation of the proposed development of 550 Washington will bring increased vehicular traffic to the neighborhood, which threatens to exacerbate these problems. For this reason, the New York City Department of Transportation must conduct a rigorous transportation study of the area, concurrently with this ULURP, so that concrete measures to address this problem can be addressed and enacted. Furthermore, the city must make a firm commitment at the outset of this project to improve conditions by implementing many tools in the city's existing repertoire, such as planted medians, special signage, curb extensions, and other features that will make it safer. This is rightly called for in Community Board 2's resolution on this application, and it's one of my top priorities. Hudson River Park Trust must submit a plan for the future use and development of Pier 40. With the extraordinary amount of resources that are being invested in Pier 40 and the effects that the air rights transfer associated with the project will have, the public is entitled to a full account of the trust's plans for the future of Pier 40. This includes any plans for the use of the pier by the public, as well as any of the pier's anticipated needs in terms of capital improvements in the foreseeable future. The draft framework for Pier 40 development criteria contained in Manhattan Community Board 2's resolution from July of this year provides a good basis for this discussion. There must be a ban on future air rights transfers from Pier 40 into Manhattan Community Board 2 catchment area. The trust's ability to earn income from the transfer of air rights was specifically bestowed for the purpose of ensuring that the trust is able to afford the expenses of major capital projects, namely the restoration of Pier 40. The 550 Washington Street proposal ensures this outcome through unprecedented density. It would be inappropriate for the trust to further earn revenue through the transfer of air rights from Pier 40 to adjacent properties, and such a transfer would place an unfair burden on the community. Furthermore, the geographic nexus for the Hudson River Park Trust's ability to transfer air rights must be tightened to ensure that all future receiving sites are within 1/2 mile of the granting site and within the same community board area. This is in keeping with the spirit of air rights transfers, and it would ensure that the same community is weighing the positive and negative aspects of such a transfer for both the granting site and the receiving site. I want to thank you again for the opportunity to deliver this testimony. This is an important project that must be executed with high deference to public good for the sake of our city's continued growth and success. I look forward to the Commission's report and continuing this conversation when ULURP brings this application before the Council. I want to just add, I said at the beginning, that this testimony I delivered today does not talk about the actual applicant and the proposal itself. It talks about the city's actions that I believe should be taken from different city agencies. I also want to say that Chair Weisbrod has spent an enormous amount of time on this project over the last 2.5 years, and he has been a total pleasure to work with on every aspect. He has had an eye on detail in every part of this application. He has been accessible, not just to myself, but to other elected officials, to the community board, and it has just been a total pleasure to work with him on this. It gives me trust in this commission and in this agency with his leadership in being able to work with him on this project, and I'm happy to answer any questions that the commission may have.
Thank you, Council Member. After that, I hesitate to ask you a question.
That's why I said it.
But I will anyway. Thank you, but thank you very much. It's been a pleasure working with you on this as well, I just might add, and we look forward to a resolution that everyone, I think, can be proud of. I do have one question about your first request to the city for a capital contribution. As you know, the history of this park is that the city and state have funded capital improvements pretty much on a pari passu basis equally. And I'm just wondering if whether you have any indication or assurance from your fellow elected officials at the state level that the state would continue to do that.
I would hope that the state would step up and be supportive of this project. I would add, though, that the tax revenue, the property tax revenue that's been associated with the redevelopment of the Hudson River Park from Canal Street to 59th Street and the incredible growth we've seen over the last 15 years all along the waterfront, the city has really capitalized off of those property tax dollars. The city's been able to take in hundreds of millions of dollars of additional property tax revenue because of that redevelopment. And I also believe that the city, and this is fine, it's okay, the city is going to, because the state legislature granted the authority to transfer the air rights, this is going to help the mayor with his affordable housing plan. Almost 500 units of affordable housing because of the state taking that action. So I don't think any of us can predict what happens in Albany or how decisions get made when it comes to capital dollars. I can't predict that. I know the governor has a lot of say in how that money gets spent, and I would welcome his support and help on this project. But I also think if we saw the mayor's announcement last week for 5 parks in the city getting $150 million over 5 boroughs, I'm glad they got it, $30 million each. It's great. If you look at the amount of money the city put into Governor's Island and $50 million for a pool on Staten Island, I think to ask for $20 million in a $7 billion annual capital budget is like pennies when we look at the big number.
Millions are not yet pennies.
Well,
but
I think if you look at it compared to other projects that have gotten significant city support, I think it's the right thing to do. And I would hate for Pier 40 and the park to suffer because of a potential stalemate between the city and the state. And it's sort of like, who's going to step up first? Who's going to give the money first? Who's going to go in first? And if we continue to operate that way, that is what's gotten HRPT in this trouble over the last 20 years, is no one wanted to take complete ownership over it, and both parties waiting for the other side to step up. I think the city should be a leader on this and step up and make this capital contribution.
Thank you. Other questions for the council member? Commissioner Delos.
Councilmember Johnson, thank you for being here. I'm just, you made a number of, I think, very thoughtful recommendations in terms of follow-up or items that should happen as part of this process. I'm just wondering if you could describe a little bit more, though, on the thought or the request related to a DOT traffic study, and how is that different than the DIS traffic analysis that was done?
So, the traffic analysis, I think, called out what they think is going to be the increased amount of vehicular traffic that's going to come to the area. And that was under the scenario of potential big box, a huge amount of parking, both things that I have issues with and I hope to resolve with the applicant during the process. A lot of the recommendations that the community board made and that I support, and I believe the borough president called out in her recommendation to the commission, are things that were recommended as part of the Hudson Square rezoning in 2013. And I'm not sure many of those things have been implemented. The local business improvement district, the Hudson Square BID, has done a bunch of good things, widening. They've done some traffic calming measures. But DOT, especially given the mayor's commitment to Vision Zero, really needs to come in and do a comprehensive study on this area. I mean, I'm sure many of you have used the Holland Tunnel, and basically Canal Street backed up all the way past Houston Street, over to West Street, over to Broadway. The entire area becomes complete gridlock, and I'm not sure DOT has made significant changes since the 2013 recommendations were delivered to actually try to look at this.
Commissioner Ortiz.
Hi.
Hi.
Quick question. You did mention the concern early on about big box on the site, and within the CB2 recommendations, they propose limiting the spaces to 10,000 square feet, and I wondered what big box means to you. Is 10,000 square feet the right level at which to set a limit, or is it something different?
So I understand why the community board included that in their resolution. I think they don't want destination retail on the space. That would bring more vehicular traffic, and they want locally oriented businesses that the area desperately needs. And so 10,000 square feet might be the right size for that. I'm willing to work with the applicant. That is in no way to discount the community board's recommendation, but I think that this project is very complicated. The retail is, of course, an important part of it, For me, big box, I think, are things that are probably over 25,000 square feet. But the layout matters, where it's located matters, what type of use it matters, if it's retail, if it's restaurant use, those type of things actually matter. I'm going to ask the applicant to enter into a restrictive declaration on whatever we come to an agreement on with regard to the retail space, the layout, and the type of uses. One of the things that the applicant, I think, was open to, and that would be helpful to achieve during this, is to get a grocery store. And I want to have some flexibility in the size of that grocery store. 10,000 square feet is not big enough, probably.
Well, I guess for the record, they say except for the grocery store, so, yeah.
So, I mean, it depends. I'm willing to work with the applicant on this and to find a thing that makes sense. I mean, one of the things, not to get too technical here, which is going to impact how we handle the retail, is if we reduce the parking, that's going to give more retail space. And my hope is that we're going to reduce the significant amount of parking that was asked for. And once we reduce that parking, that's probably going to give the applicant more retail space to actually work with. And so it's going to be a process in negotiating with them and the community to figure out what works.
Commissioner Efron.
Thank you. You mentioned safer pedestrian access. Do you have a point of view about an additional pedestrian walkway other than West Houston? Is there a location you think is right for the community?
You know, I'm of two minds on the pedestrian walkway. I mean, I understand that it does provide safety. I also think that not everyone uses the overpasses where they're built. And what my understanding is in the past, where they've been built, traffic speeds up when they see it because they think that people are crossing over the highway. And so I have a fear that, you know, you don't know how often people are going to actually use it. I think that there are other things we could do to make West Street, the crossing of West Street, safer. I think the turning from Houston Street is a problem right now. I think you could make it potentially so that you could only turn one way, which would make it safer for pedestrians, give more of a lead time for crossing. Right now, the crossing isn't that long when you're trying to cross West Street. So I think there are additional measures that could take place. I'm not sure that it's the best use of funds, given that it's a significant capital cost to build these. If the applicant wants to do it, I'm open to it. But I'm just not sure that it's the safest thing. I also want to take under advisement what DOT's recommendations are for other pedestrian walkways that have gone up over the city, and if they think it's been helpful, if they've seen crashes go down in the wake of them going up.
To be clear, I didn't mean a walkway, I meant a crosswalk. I
Oh,
apologize.
sorry. One of the things that have been talked about with the community board is building a walkway over. It was one of the big points of contention in the community board process, is requesting one of those.
Commissioner Marin.
Councilmember Johnson, thank you for being here. I would just suggest, and I've been hearing the parking, the crosswalk and the traffic issue. There's a practice in many cities where all traffic comes to a halt, all red lights, and only pedestrians are allowed to cross. I would suggest that the DOT study that.
What's that, Barnes Crossing? I think that's what it's called, yeah. Yeah.
Barn dance.
Barnes Dance.
And it was a New York City commissioner whose name was Henry Barnes, who brought it in the first place.
Only Shirley Secunda would know that in this room.
I sadly actually remember Henry Barnes, so. Any other questions for Councilmember Corey Johnson?
I want to thank you
very
again.
much.
I want to thank you again. Thank you.
Thank you.
Thank you, commissioners.
Next speaker is Shirley Secunda.
Good afternoon, commissioners. I am Shirley Secunda, and I am chair of the Traffic and Transportation Committee for Community Board 2. And I will be addressing some of the major traffic concerns. So, okay. How's that?
Good.
Okay. We know the proposed project has the potential to create a new neighborhood. But in order for it to be a viable, livable neighborhood with the kind of street life, vitality, and community-friendly interaction that a real neighborhood has, it must be welcoming to pedestrians and safe for them to walk without the threat of heavy automotive traffic barely controlled, constraining their freedom of movement and access. The project, as proposed, will bring thousands of new residents and workers to the area, and with them, intensified traffic impacts in an already stressed street environment. These impacts will be felt not only in the immediate vicinity, but in the surrounding thoroughfares and byways that lead into, away from, and around the project area. Existing increasing severe traffic conditions in the area, as Councilman Johnson very eloquently expressed, include congestion leading to the Holland Tunnel, creating backups on Clarkson, Ferry, Canal, West, and Spring Streets, with frequent gridlock and long delays. Houston Street westbound is often blocked at Varick and accumulates so much traffic by the time it reaches West Street, turning vehicles seriously in danger, crossing pedestrians and bicyclists. And as previously indicated, getting across West Street anywhere in and around the project area is highly dangerous, and it must be made safer for the many pedestrians and bicyclists who cross it to reach the Hudson River Park, especially with ever-increasing numbers of children and families going that way. The DEIS says that all but 2 of the project's adverse traffic impacts can be fully mitigated with standard mitigation methods, like changing signal times by as little as 1 second. This piecemeal, quick-fix approach fails to recognize the need to mitigate the severity of current traffic conditions and deal with their mutual impacts holistically before the project proceeds. Community Board 2 is urging that concurrent with ULURP, the New York City Department of Transportation conduct a comprehensive study and plan to improve current traffic conditions in the extended project area, focusing particularly on mitigating Holland Tunnel traffic and promoting pedestrian safety and neighborhood quality at Varick, Clarkson, Houston, Canal, West, and Spring Streets. Thank you.
Thank you, Ms. Secunda. Questions? I do have one question.
Yeah.
Is Community Board 2 working with the Hudson Square bid on, because they also, I know, have been
Yes,
looking very carefully at
we've been in
traffic
conversation with them, and they've given a great deal of input, and we would recommend them as a resource.
And it just strikes me that coordinating your efforts with their efforts, given that this is one traffic network, as it were, and one common issue, which is fundamentally the Holland Tunnel, would be constructive.
Yeah, well, we think it's constructive, and certainly the Holland Tunnel issues, which impact really on that whole area, including the project area.
Commissioner Cantor.
You know, we both remember the barn stands, but what I don't remember is why it was discontinued.
No, I am told that it actually exists in a couple of spaces around the city, and I'm not quite sure why it was discontinued. I think that in Los Angeles, I know it was discontinued because there were more and more cars, and people just felt that they were not obeying the rules. And they, by the way, reinstated it there in certain places.
Thank you.
Well, in Los Angeles, cars come before people. That's reality. Thank you, Mr. Secunda.
Another day.
The next speaker is Terry Cube, also from Community Board 2.
Good morning,
afternoon.
Chair Weiss-Browd and Commissioners. I am Terry Coode, First Vice Chair of Community Board 2 Manhattan. This is a complicated and extensive ULURP with many considerations outlined in CV2's careful resolution. In addition to the land use, open space, and traffic considerations you've just heard, there are many other important aspects, and I'd like to highlight some very briefly. To bring a neighborhood to life ensures more than buildings. You need services, you need infrastructure, you need diversity in order to ensure its success. The 700-plus parking spaces being requested attracts destination retail rather than local focused stores and community uses, and creates an undesirable auto-oriented area. Parking must not exceed the 381 spaces as outlined in our resolution. The balance of the underground space would be ideal for low-priced arts uses, including rehearsal, performance, gallery spaces, recreation, and more. This project needs fewer cars and more transit choices, including bicycle options and reliable MTA bus services, especially with all the families and seniors this development will bring. This large expected increase in residents' school seats are vital. The mix of market rate and affordable housing will mean many, many more students, especially in light of recent developments in the area, and the Hudson Square rezoning puts more pressure on existing and even the planned schools. Our resolution points out that the DEIS includes all of a school that has only a small portion of its capacity available for District 2 students, and a more accurate assessment would result in requiring seats as part of this project. We ask that any approvals of this ULURP application include sufficient space for a school within the project, or funding should be provided to increase capacity at current and proposed schools in the CB2 area. To promote diversity and a well-balanced neighborhood, CB2 is pleased to see that affordable units will be provided as part of this project. We ask that 20% of the floor area now planned for 130% of AMI be set at 100% AMI to create a wider AMI range. We also request that the senior housing have larger sized options and increased AMI bands to provide wider options for the seniors in our area. We also request concurrent development of additional affordable housing at 388 Hudson Street, where CB2 has identified an excellent opportunity at the water tunnel shaft site. Other concerns include infrastructure, such as flood protection and resiliency. The Big U must be implemented from Canal to West 14th Street in time to protect the existing and new community and provide an improved public realm. While we appreciate on-site water retention measures for the project itself, the current sewer infrastructure simply cannot handle the existing conditions. Approval of this application should include a commitment by the city to take urgent action to address longstanding sewer backups and flooding during storms throughout the area. CB2, all four of us greatly appreciate your careful study of our full ULURP response and for our testimony, and appreciates the opportunity to highlight some of our concerns and recommendations today. Thank you.
Thank you, Ms. Cute. Very, very efficient. Questions? Questions? Commissioner Ortiz.
Hi, you mentioned additional transit access and sort of the desire to provide, bus, bike. Could you speak to that a little bit more and what you'd like to see?
Well, certainly. Right now, the M21 bus does go across town, but it stops short of the Pier 40 site, and that's a deficiency that exists now, especially with seniors who are so dependent on bus transportation. Having one of the West Side buses can be diverted, additional resources, more frequent service and closer service. We understand and have seen throughout the city that moving a subway isn't as easy, but moving a bus should be. And it would open up an enormous ability for seniors and families to get to and from. And when this project site adds so much residential and senior residential buses, and well, bicycles are a really great way to get around. So maybe putting a city bike rack would be good. There is some bike parking included in this proposal already, but what about public bike parking as well?
Mm-hmm. Okay, thank you.
Thank you.
Any other questions for Ms. Cute? Thank you.
Thank you.
And thank to all of the Community Board 2 delegation here. We'll switch now to those opposed. The next 5 speakers are, and I may have a hard time reading some of the handwriting, Chelsea Dowell, Jordan Shaps, Pamela Wolf, Styra Eisinger, and Isabel Duquesne. And correct me if I am not pronouncing your name correctly. Is Chelsea Dowell?
Chelsea Dowell's right.
Right? Good.
I'm with the Greenwich Village Society for Historic Preservation. The proposed development on the 3-block St. John site is massive. 5 buildings, nearly 2 million gross square feet of space, several towers, including one that reaches about 480 feet in height, which is considerably taller than the nearby ODS Trump Soho. An as-of-right development could be just as tall, if not taller, and in many ways just as impactful, if not more so. But there is no denying that the requested approvals will be wildly beneficial to the developer, while what the public gets in return is relatively paltry by comparison. The public benefits largely consist of the $100 million toward Pier 40 repairs and about 19% of the total project space going towards affordable housing. The 25% and 30% figures often cited by the developers, of course, exclude all of the project's commercial space. While these public benefits clearly cost something, they pale by comparison to the vast increase in value and profitability the city would be giving this developer by increasing the allowable size of development by 70%, allowing the exponentially more profitable and previously prohibited residential and hotel uses on the entire site, and allowing the bulk of the development to be moved to the area north of Houston Street. While the as-of-right development could take place here is troubling as well, let's consider the proposed development's impact would be. The buildings themselves, while containing a handsome, updated, industrial-style window set within a masonry frame, would repeat this motif ad infinitum across multiple buildings at an enormous, overpowering scale. Virtually no public space is being offered, and the towers would loom over the surrounding neighborhood and shadow the adjacent park and playing fields. It should be noted that the tallest tower at the north end of the complex would be more than 3 times the height of both the new residential development being built directly to the north of it and One Morton Square development directly to the north of that, both of which already far exceed the height of most of their surroundings. And as previously mentioned, the traffic the current plan would generate would overwhelm the surrounding neighborhoods. The historic low-rise South Village would face vastly increased developmental pressure, and the entire Greenwich Village and Meatpacking District waterfront would be one step closer to further overdevelopment from the air rights transfer framework, which these approvals would establish. Our communities deserve considerably more, and to be blunt, this developer deserves considerably less. This plan should be fundamentally rethought, and at the very, very least, landmark protection should be granted to the South Village. Prohibitions on further park air rights transfers should be granted to the remainder of Community Board 2, and the traffic-generating big box store and destination retail component of the development should be eliminated. Regarding the chair's earlier questions, I would also like to note that not only were air rights transfers never really envisioned for the Hudson River Park, but the restrictions on the types of uses in the park, even on the commercial piers, means that the types of huge developments that the air rights transfers are now enabling would never have been possible or conceived of as a use or scale of development within the park. Thank you.
Very well timed.
Thank you.
Thank you, Ms. Dowell. Questions for Ms. Dowell? Thank you.
Thanks.
Next speaker is Jordan Shaps.
Oh, excuse me, I'm having an inner ear infection that's making me a little wobbly. Hi, my name is Jordan Shaps, and I speak as a Greenwich Village resident, and I represent the Perry Street Crusaders. First of all, I want to endorse every word the woman who spoke before me said. Now, Chairman and Commissioners, I want to start by saying thank you very much. In your great wisdom, a handful of years ago, you allowed a zoning change to go on a parcel of property that stood at the intersection of Perry Street and Washington Street, disallowing the building of an inappropriate 10-story, 100-room hotel with a basement restaurant of 150 capacity. In other words, a celebrity chef restaurant, not a mom-and-pop restaurant. I hope you'll apply the same wisdom in not allowing the rezoning for this project. It's totally wrong. It's a Trojan horse in my estimation. As the borough president said, it's the largest development project in 100 years in the city of New York. Doesn't it seem inappropriate that the largest development should be...
I think she said in this neighborhood, not in the city of New York.
Well, okay, all right. Well, it's still wrong. There's no footbridge capacity. There's the gardens that are supposed to be open spaces are hidden gardens. They're not accessible or welcoming to a pedestrian public. They're the gardens for the residents. The project seems more akin to Midtown Manhattan or Rockefeller Center. Why do we want to plant that in the low-rise Greenwich Village, South Village, West Village area. It's a village, that's this way, not a metropolis, which is this way. This is a metropolis. I don't want this to be like, let's modify this tiger by trimming its claws so that it'll never happen again. It shouldn't happen in the first place. So I don't see why we'll let this go through with like maybe more parking space, maybe less big box space. By the way, big box to me is IKEA or Costco and all of the commercial traffic and the pedestrian traffic that involves. We shouldn't sacrifice this. Also, the only thing I can say is that if there is such a thing as transferring of air rights for this, which I believe is inappropriate and untrue, I'm 6 feet 2 inches tall, and I'm a Manhattan resident. If anyone wants to buy my air rights, let them contact me after this session. The last thing I want to say is the only virtue to this project is if it goes through in any way, shape, and form that none of the buildings has the name Trump on it.
Thank you, Mr. Shaps. Questions for Mr. Shaps? Thank you very much.
Okay, thank you.
Next speaker is Pamela Wolf.
Good afternoon, Commissioner and Commission. My name is Pamela Wolf. I'm speaking here today for Save Chelsea, which is a community-based grassroots, Chelsea obviously, organization whose focus is on efforts to rescue and keep for our neighborhood the historic character of Chelsea. Save Chelsea feels strongly that allowing unused development rights or air rights from commercial piers within the Hudson River to be transferred inland is bad policy, will facilitate overdevelopment of West Side communities, and is not a good and appropriate way to fund the Hudson River Park. Excuse me. We opposed the state legislation which enabled this transfer of development rights and continue to believe that it should be repealed. For several years, we have joined with dozens of other community groups on the affected West Side in calling for other means to fund the park. For instance, we have stated support for applying a dedicated tax to new development in the area adjacent to the park, which would go towards funding the park. Much has been done in such has been done in Battery Park City, Hudson Yards, and Hudson Square, among other places. Such a system has the potential to generate more income for the park without contributing to overdevelopment of adjacent communities. However, this and all other alternatives suggested by community groups have been ignored by city and state officials as well as the trust, in spite of their obvious advantages. The only group which such an alternative system would not advantage is developers. Thus, we have a fundamental objection to enabling the transfer of any air rights from the park to inland areas, as the proposed special district would allow for Pier 40 and the St. John's site. Additionally, while the proposed special Hudson Square district would only apply to these sites, it is clearly the intention of this legislation to allow for future expansion, allowing air rights transfers to and from other sites within the area. State legislation allows such transfers. That means from commercial piers within the park, which includes Chelsea Piers and Pier 57, to one block inland from the park, from 59th Street to Chambers Street. Thus, while any future allowance for air rights transfers in Chelsea would require a separate additional ULURP in the future, we find it disturbing that the framework for allowing such transfers is being shaped here without any meaningful consultation with the Chelsea community or other affected communities. Much of this process has been selective and opaque, from the state legislation that allowed these air rights transfers to take place to the process by which this fully formed plan for a 3-block long development and new special district were released.
One more sentence.
Thank you.
Pick your best one.
We would like to see no air rights transfer ever allowed from the park to inland communities. However, if they are ever to be allowed and allowed in Chelsea, We demand that a much greater level of consultation and conversation take place with our community than has taken place as a part of this process. Thank you.
Thank you, Ms. Wolf.
For that extra paragraph.
Well, it was a very long sentence, consisting of a paragraph, I guess. Questions to Ms. Wolf? Thank you.
Thank you.
Next speaker is Styra Eisinger. Am I pronouncing that correctly?
So I won't bother repeating my name. I represent myself and my family and my neighborhood, my block, which is West Houston Street between 6th and 7th Avenue. So it's pretty obvious from my address that I expect to be extremely adversely impacted by this project if it goes through as planned. I am in such agreement with the various kinds of objections that I've heard that I'm not going to bother to read my statement, but I'll leave it with you. It's just basically a repeat.
Give it to the secretary.
Well, I have enough for everybody. I was told to bring 20 copies, and I've got them here.
Okay.
What I want to focus on is traffic. You are planners. What kind of planning is it to allow a development that will bring an extremely noticeable amount of additional traffic to an area that is already, as people before me have said, in gridlock? It used to be, I used to walk my grandchildren home from school on Fridays, and Varick Street would be blocked up, and I would say to them, why is there so much traffic? It's Friday, they would say to me. Well, now it happens every day after 3 o'clock. If you want to get out of the Holland Tunnel, you'd better leave the city by 2. And that's without any extra 2,500 people and stores living in this new district that you're thinking of allowing. So I don't understand what it means to plan, but maybe you have some kind of magic that you will come up with that will make it a livable place. To me, it doesn't seem to be. The only other thing I want to talk about is this whole question of air rights. So far as I can see, they don't exist because these are air rights of a structure that is over the water. And so far as I know, there is a presumption against the right to build in or over navigable water pursuant to the Clean Water Act. So what are these air rights? It seems to me this is a very tenuous strategy to raise money. And I certainly do hope that the city and the state will come up with something better than that and the various other things that have been suggested, which I'm not knowledgeable enough about to comment on, but I hope that what people have said is correct. That's all I have to say for now. I want to thank you for having this meeting and for allowing me to speak.
Thank you. Questions for Ms. Eisinger? Thank you very much. Next speaker is Isabel Duquesne.
Hello, and thank you for giving me a chance to speak today. My name is Isabelle Duchesne. I've been living in the village for almost 30 years. I've worked there and met my second husband in one of its cafes, so I feel deeply rooted in the neighborhood. Over the years, I have witnessed a lot of changes, sometimes something that I expect, but recently our neighborhood has been particularly affected by those transformations, which instead of serving our mixed community, have already destroyed a significant amount of historical buildings, numerous mixed income level residents and artists, and terminated small local businesses, and it has had a negative impact on our daily lifestyle, etc. The future of Greenwich Village is now reaching a crucial stage, and we are now facing 3 significant issues that are likely to have a very adverse effect, not only on the village, but also on its surrounding neighborhoods. First of all, we need to get the remaining sections of our Greenwich Village, the Southern Village, landmarked now. The currently proposed rezoning rules regarding the St. John site and Pier 40 section west of Houston Street and by the Hudson River, which was listed on the State and National Register of Historic Places, will endanger all the low-rise historic surrounding village areas. It will also increase the pressure to develop this site to the benefit of the big real estate industry. Secondly, any further air rights transfers from the Hudson River Park need to be at least controlled and restricted, according to me. They are wrong, and they are not the appropriate way to fund the park because they will lead to massive, aggressive development of waterfront blocks in the village and beyond, which are zones 1 and 2 of emergency. Unfortunately, the state legislation that was passed created a real danger to our neighborhoods by allowing such transfers, so we must take steps to make sure that this never happens. Why would we want to damage the Hudson River Park with this beautiful, peaceful, open, pedestrian, and natural environment, which so many people enjoy during their leisure time? There must be better ways of funding the park than by blocking the light, the river view, and access to the river through enormous buildings. Finally, plans for huge stores and destination retail should not be a development option. It will increase significantly the traffic, the parking issues, the pollution, and damage the environment. The people in the blocks around this area are already suffering from that. Just think of all the traffic congestion that lasts for hours in the residential area around. To conclude, we must act against this inappropriate development and real estate projects. And this is a perfect moment to adopt measures to protect our neighborhood and to promote an acceptable, sustainable development for its future. Let's protect and develop adequately the village. Thank you.
Thank you, Ms. Duchesne. Questions? Thank you.
Thank you.
All right, we'll now go to next five speakers in favor. Jean Dorick, Robert Attenberry, Pajmon Lodi, Michael Kramer, and Tony Simone. Welcome, Ms. Dorick.
Good afternoon. My name is Jean Dora, and I'm testifying on behalf of the Association for a Better New York. The Association for a Better New York is among the city's longest-standing civic organizations advocating for the policies, programs, and projects that make New York a better place to live, work, and visit. We represent the broad fabric of New York's economy, and our membership includes leaders of New York businesses, not-for-profits, arts and cultural organizations, educational institutions, labor unions, and entrepreneurs. Today, we are adding our voice in support of the conversion of St. John's Center into a residential building and the rehabilitation of aging Pier 40. The St. John's Center proposal entails repairing the deteriorated supported piles under Pier 40 in Hudson River Park with the funding that will come from the construction of new and affordable housing units for seniors and local New York families. In a time where waterfront access has never been more important to our communities across the 5 boroughs, and where families are struggling to afford to live in the city, we believe that this proposal can be beneficial on many levels. Pier 40, which currently provides parking and public fields used by school children, as well as youth and adult sports leagues, generates 40% of the Hudson River Parks Trust's revenue, mainly through the parking facilities. The new development plan for 550 Washington Street would generate adequate funding to cover the repairs of Pier 40, rescuing it from destruction and allowing it to continue to serve the public through its popular ball fields safely. This design also provides an elevated park and open space to the surrounding community by removing a building that completely covers 3 blocks. The new development would bring new commercial, retail, and residential space online, including up to 1,586 residential units, of which 30% would be permanently affordable in a mix of low income, moderate income, and senior housing, as well as publicly accessible open space within an elevated open park, all while creating 1,800 construction jobs along with 1,500 permanent full-time and part-time jobs. The St. John's Center proposal is a clear win-win for both New Yorkers and the city, and we support the transformation of this outmoded site into a safe and vibrant development for the community. Thank you for the opportunity to testify.
Thank you, Ms. Dorick. Questions, Ms. Dorick? Mr. Cantor.
Mr. Chairman, I'd like to ask the lady a question that I know she cannot answer, but the applicant themselves can. Can we do that?
No. If she can't answer it, I don't know what to say. You can ask her the question and it can hang in the air.
The applicant,
The applicant can get back to you. So if you want to raise a question, you can raise a question. If Ms. Dora can't answer it, the applicant can send in a response.
so I can't pose the question.
You can pose it.
Thank
You don't get it, so you get an answer.
You referenced the parking and the income from the parking. What's been troubling me as this hearing's been progressing was the suggestions by some that parking be either eliminated or reduced sharply and other activities being placed in the basement. Twofold. Number one, I assume that car count and the income from car count is in their pro forma. Number two, the requirements for a parking structure are dramatically different than requirements would be down below grade for the type of facilities they're speaking to, whether it be exercise rooms or theater or whatever. And my question to the applicant through you is, have these alternates been considered at all? What would they do to your pro forma? Is there anything you can do with regard to responding to some components of those questions that were posed by the community?
I'm going to have to defer that question to the applicant.
You going to answer that question, Ms. Dora?
Not quite.
We can find out if you're allowed to.
Not only are you asking a question Ms. Dora can't answer, you're asking a 5-part question Ms. Dora can't answer. Thank you, Ms. Dora.
Thank you.